But this matter, my lord, was directed to appear today. It has not appeared. Let it appear, my lord, in any day. It's a tribunal motion.
Mr. Das, you have seen our determination. This court will be sitting today. Tomorrow, who will be my partner, we do not know.
Lordship.
So it is better if you can mention on Monday, let the
Lordship,
bench be
Lordship,
regular.
Lordship.
Give a notice to your other side
I
and
shall.
come back and tell
I
us.
Lordship, may I mention the matter without certified copy, leave to file appeal. But this appeal arises out of a determination of municipality matter of Justice, my Lord Justice Arijit Banerjee's division bench. Lordship is not sitting today. The division bench is not sitting today.
Then it must have been given to somebody else.
I am told by the court officer that that determination has come before Lordship.
No, I just now signed my determination. That was not there.
It's not there.
কি বলছে আছে কেউ আসেনি জন
If it comes, then I will come back to Lordship.
Come back and tell us.
I will.
Group 6 appeal, wherein we are facing a contempt.
Group 6 appeal, who is your other side?
He was appearing in person. We have served him notice.
You have served notice?
Yes. But during the vacation, we received a large letter, giving us threats of all natures, be that as it may, but there is an appeal.
বিয়ে ছিল না করতে চলে এলো তাই না
Next week is complete. Next week. Huh? Next week. Next week.
Consequential. Consequential effect.
Next week.
Face the contempt and come next week.
Let him let him not be threatened further. As it is, that threat is looming large on his head.
But Mr. Mojumdar, only if it is in person, have you served that you will mention
But
today?
Mr. Unujit Mukherjee gave the notice of contempt that he is appearing, that I am told.
You have given
Yes, yes.
given a copy to him. এটা নিয়ে নাও সোমবার দিয়ে দিও
My lord.
It's a central tribunal or state?
No, it's a group 6 regular.
group 6.
My lord,
Grateful to
may I be permitted to mention one central administrative tribunal matter, my lord. The matter is appearing in the combined list. I have mentioned before vacation, I have mentioned, my lord, the petitioner is not getting pension, my lord, since 2007, my lord. Several disputes, my lord, that has been settled between the parties, my lord. And they have affirmed affidavit. My lord, only my lord,
Who
pension.
is your other side?
Other side, my lord, central government, I have served. They are appearing. I shall serve another notice, my lord.
So give a notice and tell us. Give a notice and mention on Monday. It will be better. Otherwise, it will be in the supplementary list. Again, it will be adjourned on their ground.
No, my lord, I shall serve.
Please give a notice and give that notice and mention so that we can keep track of it.
Lordship, I am inclined to mention
Without notice, please do not mention. If you have given notice, come back, give a notice, come back on Monday and tell us.
Lordship, I am inclined to mention a matter, a contempt application arising out of an order passed by His Lordship Justice Chatterjee, sitting singly in courtroom number 550, that subsistence allowance matter. This is a contempt application, Your Lordship, and I believe in courtroom number 25, Your Lordship is not sitting.
When I shall sit singly, then mention.
Grateful, Your Lordship. Grateful.
It's a hearing matter. It was requested in the month of September, but it has not yet appeared. A notice already served
Hearing matter, did you
regarding
mention
this promotion.
Did you mention earlier?
Yes, yes. It was mentioned in the month of September.
September. So wait for the combined list. It will come only in the combined list. Slipটা নিয়ে নাও combined list এ দিয়ে।
My lord, inclusion in the list, my lord. Group 1 matter, my lord, determination is given, my lord.
Yes.
New application, my lord, matter appear in the vacation bench, but not reach the matter, my lord. Very extreme urgency, my lord.
What urgency? His
Urgency,
lordship is coming back on 1st. You will have the regular bench. Yes.
My lord, upon notice, I am mentioning one state tribunal matter, my lord.
State tribunal matter.
My lord.
Motion stage.
Motion stage.
Who is your other side?
But I have served the notice upon the respondents, my lord.
Saying that you will mention.
I will mention on 16 before your lordship. I have served.
It is fresh motion.
Fresh motion, my lord.
Then it was not reached.
No, it has been filed just before the vacation, my lord.
ও আচ্ছা আচ্ছা। ঠিক আছে, দিয়ে দাও তাহলে ওটা, সোমবার দিন দিয়ে দাও।
Grateful, my lord. My lord,
Praying for him, direction is given to prefer an appeal without certified copy, my lord. Hello.
আবার ডিটারমিনেশন?
No, my lord. Determination is Honorable Justice Surya Prakash Kesarani and the Honorable Justice Bharata.
Why you are mentioning?
No, we don't, their lordships are not sitting, and most probably this,
Most probably won't do. My lords may be coming just now.
no,
Take it up.
not sitting.
We have not been given the determination. How can you give the?
It is true, my lord. As I got most probably wrong information.
করিডোরে শুনে চলে এসছে।
Lordship, may I be permitted to mention this matter? This is as an assigned matter before your lordship.
That SSC.
Yes, my lord.
Yes, yes.
We concluded our part of the hearing and there was a direction upon them to file the affidavit in opposition in the meantime, as well as to produce the panel before your lordships.
They have not.
They have not given the reply to that affidavit in opposition, my lord, till date.
Did we hear? We heard it.
Yes, my lord.
অ্যাসাইনমেন্টটা কি আমাদের দুজনের কাছে ছিল না শুধু আমার কাছে ছিল?
My lord.
রিটার্নেবল
It wa-
রিটার্নেবল ওয়েন?
No date was fixed. It should have been after vacation, my lord. On the last direction
ও
was,
আচ্ছা আচ্ছা। Give the slip.
my lord.
The slip.
Prior to this, on 2 occasions, the matter appeared before your lordships.
No, we heard it
Yes, yes.
extensively, but the thing is the bench has stayed.
Yes, my
কবে নোটিশও দেবে করতে? কালকে না। Happens.
lordship.
But this week,
My lord.
let us see what can.
Lordship.
Yes.
Lord, I have 2 applications.
Remind us next week.
Lordship.
Remind us next. Next week means next Wednesday.
My-
Remind us.
Lord, I have 2 mentioning, my lord, 2 state administrative tribunals matters.
You give a notice to your other side that you had mentioned.
Lordship,
Give a notice.
today only I will.
Now, my lord, I have 2 mentions, my lord, with regard to state administrative tribunal. Now, my lord, I need a NOC to participate in the selection process to be conducted by the AIMS Kollam. Now, my lord, the NOC is to be given to a serving doctor by 25th.
But
Is
it's
a
a fresh motion.
fresh motion, my lord, filed during the vacation with the leave of the honorable court.
Hmm.
My lord, the urgency is this, my lord, 25th is the date by which I have to appear in the selection process.
So you didn't go to the vacation bench.
My lord, I moved the vacation bench, my lord. The vacation bench ultimately matter cannot be taken up, my lord, by the vacation bench, and my lord fixed.
It was not reached.
My lord, one matter has been listed before the vacation bench, headed by my lord Justice Bishwajit Basu.
Hmm.
The other matter, my lord Justice Mukherjee has, Arindam Mukherjee has granted leave to, my lord, to file the application and my lord, mentioned before the regular bench. Both the matters are to be before the regular
So
bench.
both the matters were before the vacation bench.
Now, one of the matters before the vacation bench. And
Then what happened? In that any interim protection granted?
no, my lord, matter could not be reached on that day.
You are there. In this,
So, my lord, he's on record.
oh. So who is your other side?
My lord, Shungita Rai have served notice, my lord.
That you will mention it today?
Absolutely, yes, my lord. I have served notice upon them, my lord.
25th is the
Date for, my lord, the selection process. I have to get the no objection prior to that, my lord.
interview process. Oh, আচ্ছা। তো এটাকে 20 তারিখ লিস্টে দিয়ে দিও।
But there are two matters, my lord, same, identical issues. One is supposed to be listed, my lord, as because the Honorable Vacation Bench granted me leave to move the matter on 17th before the regular bench. But hopefully that matter may appear, my lord. Let both the matters be taken up tomorrow. Same issues, my lord.
দেখে নাও একটু।
Tomorrow, my lord, both the matters, my lord.
Not tomorrow, it will be on Monday.
Monday, yes. But should I also annex the notice, my lord? Notices are there.
Yes, give the notice. একটা notice দিয়ে দেবো তো?
My lord, may I permitted to mention one matter, my lord, at tribunal hearing, state administrative tribunal hearing. Fresh motion, my lord. I have served notice that it will be mentioned today.
চলো Monday দিয়ে দাও।
Grateful.
Fresh motion.
Fresh motion, my lord. It is filed before the puja vacation and the detainable date is mentioned as 20th.
Grateful, my lord. My lord, should I serve notice once more, my lord? As because I mentioned today, should I serve once more notice? I will serve, my lord. If
You have already served notice. That is your choice.
As-
Yes, call the list.
My lord, may I have my lord's kind leave to mention, my lord, very urgent application pertaining to the list of, my lord, the division image of my lord Justice Boshak.
What is the urgent?
My lord, the urgent
Matter. Land matter.
land matter. My lord, the urgency is,
Your notice.
I have already given notice, my lord.
Give a notice and mention on Monday.
My lord, the urgency is, my lord, may I say this?
We will hear you on that day. Monday we will hear.
But
Yes.
the urgency is, my lord, on the any day. I'd be under threat of, my lord, a consequential, my lord, my lord, steps, not only for termination, but also, my lord, there may be a threat of, my lord, banning of my livelihood. So for the
Termination for what?
termination of a lease contract of mining lease, I say that so far the execution of the excavation of coal is concerned, that is subject to statutory permission.
Where is your notice that you will mention today? Have you
My
given
lord,
notice?
I undertake, my lord, I have,
Give notice and come.
my lord, may I only take this indulgence? I'm extremely sorry, my lord. I would give a notice and come back at 2, my lord. It is a very urgent, my lord.
Not to come back tomorrow. Let us. Yes. Call the list.
My lord, I have got one matter to mention, my lord. I mentioned that matter, my lord, before vacation, when your lordship's desire was to mention, I should mention after vacation, if it is not taken up. It is item number 115 of the combined list. The petitioner.
You remind us on Monday because we do not know whether my brother will be sitting tomorrow with me or not. We do not know. So
Right.
let us see whether the bench remains the same or because determination is with myself and Justice Velumoni. For today only the determination has been given. We do not know tomorrow I may lose my partner. So let us see what happens. Come back on Monday.
Yes, full lordship.
Well, item 1, my lord, is fixed for hearing of appeal. My lord,
Yes, Mr. Sen.
my lord, I can start today. I can start today. So for the facts and other things are concerned. But my lord, I should be fair and that I cannot finish today because kindly consider one thing that today is the my lord, first day after reopening. So lordship, my lord, so far the other books and other thing, my lord, the Xerox copies of some judgments I required.
You are there.
Yes, I am for the respondent writ petitioner.
Because of his mentioning, my lord, fix this matter.
What is the issue? Tell us.
My lord, issue is this, my lord. The writ petitioners respondents, they, my lord, they belong to a separate class according to them, because all of them ওটা কোন সার্কুলারটা ছিলেন? My lord, all my lord, they, my lord, filed these writ petitions. My lord, they filed this writ petition, the respondents herein. My lord, they were, my lord, the employees of NBSTC, North Bengal State Transport Corporation.
Yes.
And all of them retired prior to 1996.
Hmm.
They clubbed together and they filed this writ petition. There, my lord, the sole grievance is that after retirement, they filed it, my lord, sometimes in 2004 or 2006, the writ petitions were filed, retired prior to 1996. Their sole grievance is that their amount of pension, the pension what they are getting after retirement, that was much lesser than the similarly circumstanced employees of Calcutta State Transport Corporation, the other transport corporation, who retired also prior to 1996. The only issue is that whether that pension calculation on the, my lord, on the basis of which they are getting their pension as pre-1996 retiree, whether, my lord, there is any, my lord, there should be any grievance or not with regard to that quantum, in comparison with the similarly circumstanced employees who retired prior to 1996 from Calcutta State Transport Corporation.
So they are claiming higher benefit.
Higher benefit, that means higher amount of pension.
So those the persons who retired,
my lord,
accepting the pay scale,
my lord,
they are not before us, or they
no,
they have got the pension. These writ petitioners,
they, my lord, claim that they, my lord, belong to a separate class for being retired prior to 1996 from North Bengal State Transport Corporation, and only their pensions, my lord, the amount, the calculation, that is, my lord, the lesser than, my lord, the pension, my lord, getting by the Calcutta State Transport Corporation of retired employees, similarly circumstanced, who retired also prior to 1996.
What did the single judge say?
Now, my lord, I'm coming to that. Now, my lord, initially, my lord, they filed a petition before this Hon'ble court in sometimes 2004 possibly, and my lord, they were asked to, these private, the respondents, the petitioners at that point of time, were asked to make representation before the two separate authorities. Similar representation, but two authorities. One before the Principal Secretary Transport Department, and other before the Principal Secretary Finance Department of the Government of West Bengal. Because the North Bengal State Transport Corporation, though, my lord, under the, my lord, Road Transport Corporation Act 1950, it is an independent body.
What happened?
Well, I'm coming. So far, the representation, my lord, considered by the Secretary Transport Authority, I mean Transport Authority Secretary, that did not consider all the issues. All the issues. Only thing that you are not entitled, and matter should be referred before the Finance Secretary, because the finance should be involved of the Secretary, and already that representation already dropped before the Finance Secretary. So practically no order practically passed by the Secretary Transport Department. Next matter came up before the Finance Secretary. Now, my lord, Finance Secretary, my lord, after giving it, my lord, the hearing to the writ petitioners, now, my lord, a lengthy, my lord, the order, or my lord, the discussions, after discussions, order passed rejecting their claim on the basis that after going through the records, it appears that prior to 1998 ROPA, Super Calcutta State Transport Corporation employees with whom they are comparing themselves, Calcutta State Transport Corporation employees' pay scale remained same when they retired. in before prior 1996. But so far the North Bengal State Transport Corporation employees were concerned, so far the present respondents' lead petitioners are concerned, their pay scales were enhanced and revised in terms of ROPA 1998. Because ROPA was given effect to prior to that.
So their claim was accepted.
I'm coming to that. As per the Finance Secretary order of the my lord so far, after disposing of the representation, that you are not entitled to. The similar benefit cannot be given to you. The similar amount you are not entitled to. They are claiming.
What did the single judge say?
I'm coming to that. My lord, the main thing is that their claim was that 148% DA should be included in their basic pay before calculation of pension. 148% DA, this is the main, my lord, the crux of the matter, whether they are entitled to or not. 148% DA should be included with their basic pay before calculation of pension. And what is getting by the similarly circumstance retired employees of Calcutta State Transport Corporation. No doubt they are getting that. But so far the Calcutta State Transport Corporation employees of pre-1996 were concerned, they were getting that 148% DA because their pay scale was unrevised. And here, after revision of pay scale of this North Bengal State Transport Corporation, that DA already included. So when the basic was, my lord, taken into account for the purpose of pension calculation, that basic already included that 148% of DA. And this is exactly reflected in the order of the, my lord, the Finance Secretary. The Finance Secretary said that the DA is because of CPI, that is, my lord, the consumer that index. And that consumer index considered was totally different in comparison with that Calcutta State Transport employees. Your CPI is different for their CPI. So that is why you are not entitled to. So double benefit cannot be given. And my lord, the learned judge, my lord.
Another aspect, whether price index or nothing, whether the DA was included with their
yes,
or DA was included in the basic of the employee of P1996 retiree of North Bengal Transport Corporation or not?
True. Now, my lord, in the read petition, my lord, they have not denied that. That no.
You did not contest the read petition.
No, my lord, yes, that is the whole difficulty, my lord. That nobody turned up, no affidavit filed, and my lord,
My lord, 148 is the order MP. Page 148.
Contempt you have filed. You have filed any contempt application?
My lord, earlier it was filed but my lord, I have given an undertaking that till disposal of this appeal, my lord, I will not proceed. And thereafter, my lord, stay was also granted on my.
And my lord, there is, my lord, another point that.
But why you are seeking adjournment, Mr. Sen? This was heard by the division bench.
Yes,
we heard it on. It was heard by Justice Velumoni. Then also time was taken.
And my lord, there is another point, my lord, the crucial point is that, my lord, the learned judge also on the basis of their, my lord, the averment, considered one circular of October 27, 1998. Well, that October 27, 1998 circular, my lord, for the basis of calculation of pension was, my lord, specifically meant for government employee. And my lord, other corporations, my lord, specifically exempted from giving effect to of that circular. And they relied on that circular, and learned just said that considering that circular, a fresh calculation should be given.
No, we find that a coordinate bench passed an order on 22nd January 2019.
Yes.
Formulating 2 points. Have you gone through that order, Mr. Sen?
My lord, right now, my lord, it is not with me, my lord. 22nd January 29, na? 22nd January
2019.
আছে, judgment আছে। দীপঙ্কর দত্ত নাকি?
হ্যাঁ।
এই অর্ডারটা দেখাও না।
My lord, I have given.
You have given?
Yeah, yes.
So did you, after that, what happened? Did they
My
use
lord-
any opposition or?
My lord, when the appeal was taken up for hearing, my lord, on the very first date, my lord, the honorable coordinate bench was of the view that, my lord, I have denied to file any opposition because of this person's condition. Now, my lord, then on that very date, the honorable coordinate bench had directed that the matter will be heard on, my lord, on hearing basis.
But with 2 matters. There
Yes,
were
2 matters. Now, my lord,
Where is the other matter?
my lord, other matter, my lord, in the other matter, the affidavit was exchanged and the matter was decided on, my lord, merit.
Decided.
Yes, and my lord,
The single judge.
single judge, my lord, upholding the claim of the writ petitioner. Yes, they are entitled. Now, my lord, they have preferred the appeal. My lord, thereafter, my lord, it was filed by some separate person. My lord, it was Shri Prashant Kumar Goswami was the writ petitioner responded. Now, my lord, what I have been told that that person was expired in the meantime and he had no legal heirs left. That's why, my lord, perhaps it was abated.
No, my lord, what happened, my lord, then when the matter came up as a final hearing of that matter, now, my lord, the honorable, my lord, the division bench, my lord, asked me that to inquire that whether any heirs are, my lord, any heirs are left or not, whether now, my lord, my instruction was that no. Then their lawyer also submitted that nobody to
There was only one writ petition.
one writ petitioner. He was the bachelor. Now, my lord, ultimately, my lord, the court, my lord, they came to a conclusion that the matter be dismissed. But all the merits, my lord, that order is not with me right now. Just, my lord, the fortnight before the vacation, the order passed that, but all the points which
Give us the order.
no, my lord Justice Velumani's division bench.
This is
But
the
all the points, since the similar points are involved also in other pending appeal before your lordship right now. So all the points are left open. There would be no, so all points are left open, and that all points would be heard before that pending appeal because the similar issues are involved.
My lord, the coordinate bench, which was passed the order in Prashant Kumar Goswami, my lord, I am
Mr.
carrying.
Prasad, then
Yes.
let us do one thing.
Yes.
Justice Velumani would be sitting here. That is the determination, what it says.
Yes.
So we simply adjourn the matter till Monday. When her ladyship has heard the matter, then she may be a party to the bench and
Very good.
proceed.
Yes, my lord, I,
It on Monday, and if on Monday her ladyship is any difficulty, we will fix a date and finish
Very
it.
good.
yes.
My lord.
এই বলো। এটাকে লিস্টেই রেখে দাও।
My lord, only a prayer that I am making, my lord, because
We understand your anxiety.
yes, my lord, because
That is why we fixed it today.
yes, my lord, let it be, my lord, finally, my lord, let it be concluded that was the, my lord, otherwise this person will not, my lord, see the fate of their appeal because they are all are bedridden.
Mr. Prasad, we didn't say that it should not be concluded.
Yes,
We
yes.
are making an
No, no, my
endeavor
lord,
to
I am-
see that it is concluded.
Yes, my lord, I am grateful.
Mr. Sen, you come ready on that.
My lord.
Monday it will be all right.
My lord. My lord, if your lordship should desire, my lord,
All right, Tuesday.
Tuesday.
Tuesday. We give
Tuesday,
it
my
on
lord,
Tuesday.
perhaps Tuesday is the holiday.
Tuesday holiday.
We yes,
Tuesday is the holiday.
Chakraborty puja.
22 তারিখ রেখে 22nd it will be there. 22nd is a Wednesday.
22nd.
I'm grateful, Your Lordship.
It will not be in the list, it will reappear on 22nd.
22nd. I'm grateful. My lord, it will appear in the same heading, my lord. It is appearing today in the fixed matter. I'm grateful.
So today, my lord is not passing any order, only that it is understood that the
It will be on Tuesday, Wednesday.
Wednesday.
If it fixed matters are kept, you mention before us, we will fix a date and fix. Yes, next.
No. And in all earlier occasion, this matter, my lord, learned Advocate General appeared. Now, my lord, if the Advocate General, my lord, if for any, my lord, inconvenience, my lord, may not come, then I shall.
Is for the petitioner. You are
No,
for the
I am
petitioner.
item 1, I say.
Oh, item
I am
one,
appearing for the
Advocate
state.
General was
Always appeared, but if he
No, you
does
are
not,
doing
I shall.
Yes. Who is into?
But I beg to appear item number 2 as a respondent.
Respondent?
Yes, state respondent.
It's for the petitioner.
I believe Mr. Hon'ble Basu. But the difficulty is that this matter was initially fighting by the different set of the lawyers. I have been newly entrusted with this case, Millet. I do not have the copy of everything, Millet.
What are the applications about?
But this application, I guess, Millet, this is the section 5 and
those have been allowed.
Millet, I have no clue about the same, Millet.
Order sheet first.
দাঁড়াও না
চেক আপ করে নিও 22 তারিখ থাকবে
ব্রিফ নেই বলছো তুমি আমরা বলছো যাচ্ছ
ফাইলটা চেক আপ করে নাও অ্যাপ্লিকেশন পেন্ডিং আছে কিনা কাম ব্যাক অন ওয়েডনেসডে
as well as
ইয়েস একটু চেক আপ করে নিও অ্যাপ্লিকেশন
But I am for the respondent in this matter.
Lord, I am for the petitioner. Mr. P.K. Drolia is out of his station. Mr. Senior Counsel P.K. Drolia is out of station, so I am praying not this week.
Who is the
P.K. Drolia.
My lord, problem is this, my lord. These honorable bench has heard out the matter at length. Last occasion.
Lord, he will return on Monday. Kindly fix it on Wednesday. Any days, Lordship, please.
দেখি অর্ডার শিটটা দাও তো
Now kindly see the order sheet. Last occasion, these honorable bench has heard out this matter.
What can be done, Mr. Thus we cannot make it part-hard.
That is the problem. Again, my lord,
Part-hard will again create a problem for you.
again, my lord, bench will be changed, and again, my lord.
When he is coming back?
He is coming on Monday.
It will be there in Wednesday list, 22nd. Yes.
Lord, Mr. Kushal Chatterjee is appearing for the appellants. He is engaged in another courtroom.
Lord, in this matter, Mr. Tanmoy Mukherjee is appearing for the respondent. Today, due to his mother's annual Sat ceremony, he will not come, Lord. That's why, Lord.
Is this that order?
Order 22, Rule 10.
Myself and my brother has heard it.
My lord, my lord, my lord.
So we make it part-hard before this bench. When this bench will sit, it
Lordship
will
pleases.
appear as a part-hard matter.
My lord.
As your lordship pleases.
This is that substitution.
Yes, my lord.
তাই বলেছিলাম substitution
হ্যাঁ
that it was transposition.
Transposition. Original plaintiff died, their son is the
as the matter has been substantially heard by this bench, comma, the same is treated as heard in part. The same is treated as heard in part.
and which
Whenever we will fix up, if the bench changes, we will fix up a date and keep the parted matters and so you please keep a watch on
my lord,
this.
my
Do we need to mention the matter?
We shall এটাকে এই শুনুন ওনার সাথে একদিন একটা বেঞ্চ করে দেবে কবে একটা বেঞ্চ করবে
my lord.
Even this bench will sit and take up. You are there. Release the matter for further consideration on 8th.
This bench is not available regularly now.
That is why we have, my brother has heard it along with the
Yes.
substances. We have made it hard in part and we have kept it on
Great.
8th. We will sit together and finish off the matter.
Very short point.
8 তারিখ রেখে দেবে 8 তারিখ সেভেন্থ
My
চেক আপ করেছো তো ভুল হবে না তো তাহলে আগে থেকে ওটা ইয়ে করে দেবে একটাও মামলা effective
But I'm for the petition, my lord.
I am for the West Bengal State Legal Aid Service Authority responsible
that
for
matter.
That
where
matter.
there is a
They have
specific
not
direction given to the state authority to produce the
filed a report in the form of affidavit. My lord, last occasion, they have also not appeared. I personally actually intimated the state. It has been-
দেখি দাও অর্ডারটা এটাও তো শুনেছিলাম কি করবো লেখো as the matter has been we are making it as hard in part it will be there on 7th
As your lordship pleases. But in the meantime, my lord, the members.
any improvement any improvement in the meantime
But can you look into this?
দেওয়া হয়ে গেছে ওটা আগের বার দেওয়া আছে।
হ্যাঁ
Can you look into this communication made by the member secretary to the judicial department?
yes this you placed
But
before
that has been already placed before your lordship. But probably on the last occasion, my learned.
Mr. Ghosh, we were
Yes, yes.
thinking you have to withdraw and challenge that
Yes.
order.
They have not come with any steps, any order there. No order is there. Nothing, no steps has been taken. Let them know the fate. At least there should be an order. There should be a communication. Nothing has been done.
But still the
Everything is
government
pending.
has not done anything, lordship. They have to come.
Thing is pending. Let them take a decision. Let them come pass an order.
As the matter has been substantially heard by this bench, ওই যেটা দিয়েছে the same shall be treated as hard in part. Stop.
Department ke diche.
In spite of
The department ke diche.
uh, Mr. Ghosh, learned advocate appearing for the appellants, informs us that in spite of the earlier direction dated 14 September 2023, no affidavit has yet been filed. No affidavit has yet been served upon the no affidavit has yet been filed by the Principal Secretary, Judicial Department, Government of West Bengal. কি বললে Mr. Ghosh informs us that in spite of an earlier direction dated এত, তাই তো? No affidavit has yet been filed by the Principal Secretary. Stop. In spite of service, no one appears on behalf of the state respondents. Though Dr. Shahara learned advocate appearing for the respondent numbers 3 to 5 is present. In view thereof, please the matter for further consideration. On 7th December, it is made clear that in the event the earlier direction of this court dated 14 September 2023 is not complied with, this court would be constrained to direct the personal appearance of the concerned state respondent. Yes, stop. Mr. Ghosh is Mr. Ghosh is directed to immediately communicate this order to Mr. Bari, learned advocate who entered appearance on behalf of the state respondent. Stop.
Deeply of your lordship, deeply.
এই নাও এই কাগজগুলো ফেরত দিয়ে দাও।
Well, this communication may be taken on record.
এটা দেয়া this is after 14 September.
No, it's communication.
This is
Notice,
after-
yes, ma'am. Notice to the other side. that
But
the matter
notice
is
to the other side, that the notice which has been served to the learned advocate of the state respondent.
that the matter will appear today.
ও আচ্ছা, ওইটা কি লিখেছো না মিস্টার ঘোষ? হ্যাঁ হ্যাঁ,
Harden part করে রেখেছো?
Harden part.
তারপরে কি বলেছো মিস্টার? তারপর let the document as regards service upon the state respondents, comma, be kept on record. As regards service upon the state respondents, be kept on record.
Much of.
Inform this order to Mr. Bari.
Yes, I much. Harden part করে সাবমিট।
My lord, I am for the appellant petitioner. Last occasion, on 20 September 2023, Lordship directed to the bank authority concerned to produce the rules in respect of the second so-called notice. Why these provident fund amount are totally forfeited from the appellant's accounts. If you kindly see the order dated 20 September 2023.
My lord, I am for the bank.
Hmm. এইটা শুনেছো তো? ওই যে অনেক drop হয়েছে। এখানে loan sanction। This is that loan sanction.
My lord, the dismissal of this bank manager, the misconduct not with the proportionate to the misconduct. They are shockingly harsh punishment.
পেপার বুকটা দিয়েছো?
You are directed to produce the relevant rules.
Yes, my lord.
No, first remind us the disciplinary proceeding was initiated against you. You were the manager of the said bank. Now the charges were established and your services were terminated.
Yes.
Challenging that, you preferred a statutory appeal. That was also dismissed.
My lord. Confirm the order of the disciplinary authority.
Uh-huh.
That is also dismissed.
Now challenging those two orders, you approached the writ court. Writ court said that writ court dismissed your writ petition.
Yes.
On the ground.
In absence of these documents, that is the inquiry report, are not annexed with the writ
Yes,
petition.
as it was not annexed to the writ petition was dismissed.
Filed appeal.
Appeal was filed.
My lord.
Appeal court modified that portion, said that no, it ought not to have
Left
been
out
done.
documents included with this paper book.
Left
all
out
the left out
documents you have incorporated in the paper.
Lord,
Very
my
good. Excellent. When was it last heard? Do you remember?
last order.
আরে শুনেছি কবে last?
Last lordship on the 20 September 2023.
রবিপদ মুর্মু।
My lord.
শুনেছি। এইটাকে শুনে কথা রবি বল। Yes. Now, when was this ordered? When was the
List of date.
in the meantime, you have retired.
Retired.
When did you retire?
31st December 2018.
Retired 31st December 2018.
My lord.
Now, thereafter, they issued the show cause notice.
No.
Show cause
No,
notice.
19, no, not 19, 2009. That was the typographical mistake. 2009, my lord. Not 2019, 2009. Second show cause notice in the order, there was reflected that the 2019, not 19, 2009.
When was the order of termination?
But the order of termination, my lord.
19th of August 2008.
Yes. My lord.
And the appellate authority order was
30.
13 December 2008.
Yes. My lord, this is the list of dates.
দাঁড়াও না, তারপর,
Yes.
হ্যাঁ?
সুবিধা হবে।
That you have given to us. List of dates.
No, not the list of dates. That was the loan sanction prior to.
Now, thereafter, the appellate authority, your writ petition was dismissed when?
Writ petition was dismissed on
20th September 2023.
Lordship.
Our lordship.
No, my lord. 20th September was your lordship.
18th April 2022.
Just.
This is a list of dates. There are 15. Serial number 15.
18th of April 2022. Now, this show cause notice which was issued to you subsequent to termination, show cause notice was of 2009. Now, by that time, you were terminated.
Yes, my lord. My lord, may I submit? I am giving you the gist, my lord.
Second show cause notice only for the prior to that was terminated. 2009.
Exactly, right.
Absolutely
Yes,
correct.
now Mr. Pal, you argue.
Yes.
He said that where is that first show us that show cause notice?
Yes, my lord.
Show us the show cause notice of 2nd of July 2009.
Second show cause notice, lordship kindly see the.
It is in the paper book, my lord.
Page ta bolte hai.
Yes,
paper book.
Yes, my lord.
Page number. Page number 80.
80
of the paper book number 1, volume 1.
Provident fund টাকে forfeit করে দিয়েছে। So, in the writ petition, you did not challenge the show cause? In the writ petition, you challenge the show cause notice?
Malas, everything has been challenged.
Show us that you have challenged
in the writ petition. That was the annexure. Can you see this? That was the annexure of the writ petition. In the
that was annexed to the writ petition. Show us the prayer portion, na? Have you challenged? No. না, এটা তো মেমো হবে। 254. Where is the prayer portion of the writ petition?
My lord, page 145.
145 start from 145, start from 145 paper.
Volume 1, paper book, volume 1.
And 47, 147.
You prayed for reconsideration of the matter.
Yes.
In the year of 2011,
You were dismissed. You were dismissed in 2008.
Lordship.
Now appellate authority order was
30
December 2008.
30 December.
And writ petition was filed in 2011.
11. And the Honorable Justice, this Korgupto,
Where is the challenge to the show cause in your prayer?
within the representation that all these facts are also.
Show us that.
No, my lord, prayer is, there is no such prayer.
Is that the representation?
Yes, my lord.
সুন্দর petition draft করেছেন না?
Though it has been annexed, but there was no such prayer, my lord.
এটা গল্প petition এটা চ্যালেঞ্জ করবে। Representation হয়তো আছে। Where is your representation, Mr. Biswas?
Lordship, kindly see the page, start from page number, page. Big representation. There this page 232 start.
Where you have said about that show cause?
Lordship.
এই যে সেকেন্ড বলেছে পেজ 233 তে ফার্স্ট প্যারাটাতে দেখো 2/7/2009 এটাই ছিল শোকজের, সেটার গল্পটাও বলেছে প্রিভিয়াস পেজে। আফটার ইলিগাল ডিসমিসাল I have dues as well as one mercy petition. It was considered by the judge. Having happened pass away. So this show cause of 2nd of July 2009, that is at page 80. Page 80. Thank you. Yes. Now you tell us, Mr. Park.
Yes.
You place the show cause and tell us what.
Yes. My lord, I am just giving
Just let us go through the show cause. We were charge sheeted. Working as an Where is your syndicate bank officer employees conduct regulation?
my lord, that has been annexed in my affidavit in opposition R1.
Achha, page number?
Yes, my lord, I'm giving. Just a minute, my lord. My lord, page number 308 of volume 2, paper book volume 2, 308. and it is the part of my affidavit in opposition R1.
Now, where is this rule 19A?
Rule 19A regarding
Provident fund.
Provident fund. Yes, that I will place. That I will place. That I will place.
But Mr. Pal, this amount allegation of sanction of loan, the money which was given, all those loan amount have you recovered?
No, my lord. No, my lord. My lord, I am maybe it was hard long time, my lord. I am giving a short description, my lord.
Please.
Yes.
Okay.
My lord, the appellant was the manager of Didian Syndicate Bank, and my lord, as per the government policy, that syndicate bank in the year of 2020, it was amalgamated with the Canada Bank. And my lord, at present, Canada Bank is stepping in the shoes of Syndicate Bank, my lord.
That was in 2020.
2020, my lord. The date was 4/3/2020. The date was amalgamation. My lord, everything happened long before amalgamation, during the period of Syndicate Bank. As Canada Bank has amalgamated with the Syndicate Bank, and my lord, now as per provision, Canada Bank is
now this
appearing and
Syndicate Bank has amalgamated with
Canada Bank.
You are Canada Bank.
Yes, I am for the Canada Bank, and it was amalgamated by the government circular
4th March 2020.
4th March 2022. And my lord, appellant was the branch head, one of the branch of Bhavanibati, my lord, during 2005 to 2006, my lord. And my lord, a charge sheet was issued against him on 12/6/2007. 12/6/2007 for abusing official position and power, my lord. And my lord, appellant was awarded punishment dismissal from service with immediate effect by the disciplinary authority on dated 19/8/2008. 19/8/2008. My lord, and the order of appellate authority was passed on 30th December 2008, and it was confirmed.
13 December. 13 December.
Yes,
2000.
13 December 2008, and it was confirmed the early, order of disciplinary authority, my lord.
Now you issued the show cause for forfeiture of the Provident Fund amount.
Yes, yes, yes. And the appellant and participated in all the proceeding before disciplinary authority and appellate authority, and he has replied against the inquiry report and issued a letter on 28/8/2008, and it was in page 294, my lord. It is 294 of the
Yes.
And charge sheet was issued on the against the appellant and by a letter dated 1/12/2005 and 20th/10/2005 issued by the circle office, prohibited the then branch manager, this is the appellant, not to pass any loan towards anybody, and violating all these instruction, my lord, he continued to sanction loans to the parties even who has no credit worthiness, and my lord, even and to the tune of 1.02 crore. And my lord, some portion of that loan has been recovered after that, but still there are a large amount is pending.
Where is that? You have stated that in your opposition.
Yes, my lord. Yes, yes, my lord. Yes, my lord. I am giving. I mean,
you have not forgotten Mr. বিশ্বাs's claim was that charge sheet was issued on the plea that he did not have the power or jurisdiction to sanction loan.
Yes, that is correct.
Letter which was issued, that was subsequent to the sanctioning of loan. This
No. That was not correct. My lord, kindly.
Let us go point wise.
Yes, my lord, come to my affidavit in opposition.
Yes.
That is in volume 2 of this. My lord, it is R1, R2, and R3, page 331 and 332. My lord, it will clear to you, my lord. My lord, have a look, my lord.
Yes.
Page 331 and 332.
Hmm, 331.
Yes, my lord, volume 2.
Yes.
Yeah, in 331, in the bottom, again you are instructed not to sanction /release further loan until we accord clearance for the purpose.
Now, where is that earlier communication that he was debarred from sanctioning loan?
Before this,
Because you have said again you are.
yes, that day I submitted. I informed my client to produce the letter, whether any letter issued before that. But my lord, till now, I'm sorry, my lord, they could not find the letter because you know that it has been amalgamated from some syndicate bank to Canada Bank. All the documents has been handed over by the then syndicate bank. Maybe it has been misplaced, or they are not getting the thing at this moment. My lord, if your lordship insists, ask, give us so time, they will find out.
No further time.
Yes, my lord. And after that, also, my lord, the next letter, 1/12/2015, very next page, they are also in the bottom. Again, you are advised to exercise the restraint in entertaining fresh proposal until such time we accord clearance. However, in exceptional cases with merit of sanction, such process notes shall be sent to us for advance for clearance and sanction price to their disbursement. My lord, nothing has been considered. My lord, he violating all these things, though he has annexed a letter which is subsequent to this two letter, that is of 2006, as if that he has been prohibited not to sanction loan since 2006 onward, but it is not correct. Even before that, 2005, two letter which I have annexed, that has been issued to him.
Where are those two letters?
Yes, that 331 and 332, which I have just now referred.
This is of October 2005 and December 2005.
Mr.
বিশ্বাs's contention was that all the loans were sanctioned on and from the months of July 2005 to.
No, my lord, it is not clear.
It is already handed over to my friend.
Yes, my lord, I am showing.
With the charge sheet, lordship.
আবার কথা বলে।
I am extremely sorry, lord.
My lord,
They have handed over to you the list of loan sanctions.
Yes, my lord.
Yes. Sheet already handed over.
Just a minute.
ওর আর্গুমেন্টটা ছিল যে এগেন করেছি মানে আগেও এই রেস্ট্রিকশনটা ছিল। Very good, Mr. Pal.
My lord, yes, I got. My lord, in the first page, those are the loan sanctioned before that. But in the second page, you lordship just have a look on the dates.
Yes.
All the loans has been sanctioned after issuance of this letter, these two letter. All the you just have a look, my lord. It is first loan was 24/1/2006, 24/2/2006.
Yes, you are
yes,
right.
everything.
All
Some
the
loans
were sanctioned in the month of January, February, March of 2006
Six.
in the first column.
Yes.
Next was on and from 30th of December 2005.
Yes, that is also after.
Later was 21st October 2000.
Yes, ma'am. That is all the loans are after. And in the first page, that is previous to issuance of these two letters. Yes, my lord, the thing is that
now this contention of yours, Mr. Pal,
yes,
was it considered by the disciplinary authority
yes,
order?
yes, my lord, everything has been considered. My lord, natural justice has been provided.
Can you show us that portion of the disciplinary authority order where this issue of having jurisdiction was considered?
My lord, for that purpose, I have to go through. Wherever it is coming up from your lord, I have to go through.
No, it came earlier also.
My lord, for the first time, your lordship is asking this information. I am not at present. I am not prepared for that.
No, your charge was.
Yes.
Your charge was come to the charge sheet.
Yes, my lord.
That is at page 200 and.
My lord, kindly see the 387, paper book number 2, 387.
Mr. Vishwas, we will hear you in reply.
No,
let him finish it.
Yes.
Come to the charge sheet, page 259.
259. Yes, I am coming. Yes.
Articles of charge.
Yes.
You are working as branch manager during such and such, and while working, you abused your extended credit facilities in blatant manner without proper pre-sanction appraisal of the credit proposals, without ensure utilization of without proper post-sanction follow-up and control, and thereby unduly recommended. Now let us. In the process, you extended credit facilities in connivance with a placed on record false post-sanction inspection reports, made several another from one account to including account to the tune of rupees eto, even after withdrawal of your sanctioning powers.
Yes.
This was the charge.
Yes.
So where is the discussion as regards this issue?
My lord,
Achha, you proceed in your own.
I have to go through in that way.
So you proceed in your own.
Yes, yes.
Now, what do you want to point out to us?
Yes, my lord, my contention was that he was restrained by the authority not to sanction the loan. Even after he continued to sanction, and he has sanctioned the loan to the tune of the amount who was mentioned in the chart sheet, my lord, and most of that amount has not been recovered yet. And my lord, the amount is not important, my lord. It may be rupees 1, but the thing is that the way he has sanctioned the loan, that was unauthorized and improper, unbecoming as a bank official. As a bank official, he must obey the instruction of the superior office, but he has not done so. In spite of instruction, he has continued to, and he is taking plea that give loan to the downtrodden people, but it is not so. My lord, my bank policy was not that. Bank should sanction loan after following some procedure. He has not followed all these things. And my lord, when he has sanctioned the loan, there are, I took the point in my affidavit in opposition. My lord, I am referring that, my lord. My lord, my affidavit in opposition started from 287. My lord, I am coming. My lord, in paragraph number 12B, my lord.
Yeah,
it is-
just 1 minute.
Yes, ma'am.
Yes, page.
Yes, my lord, page 292, my lord. 292 of volume 2.
Yes. Paragraphs.
Paragraph, my lord, 10, my lord. In my affidavit in opposition, my lord, I'm just reading. The order of dismissal was passed duly following the procedure laid down under syndicate bank officer employees within bracket discipline and appeal regulation. The appellate authority has also disposed his appeal on merit on such and such date. And what the representation he was referring, my lord, I categorically stated there was no provision for any such representation or mercy petition under the discipline and appeal regulation 1976 in this regard. My lord, in the very next page, paragraph number 12B, my lord, I am just there are the charges that disciplinary. I am just reading, my lord, to be with further reference to paragraph 5, I specifically that the disciplinary action was initiated against the petitioner via charge sheet number such and such dated 12/7/2007 for failing to take all possible steps at all times to ensure and protect the interest of the bank and to discharge his duties with utmost integrity, honesty, and devotion and diligence for acting in the manner unbecoming of an officer employee of the bank by abusing his official position. Number one, extend credit facilities to some non-existing units in connivance with the middleman. Number two, my lord, place on record false inspection report. Number three, sanction of loan in the name of a party without his knowledge for misusing the proceed for himself. My lord, next, make unauthorized adjustment through many accounts, including that of himself. My lord, that is strictly prohibited. And he himself, from his personal account, transferred in the tune of 1 lakh rupees to a person, my lord, which is certainly not to be done by any bank official. He has done so, my lord. And my lord, sanction of credit facilities even after competent authority withdrawing sanctioning power vested in him while he was working in that branch. My lord, I am coming. And my lord, in paragraph 16, I have stated, it is 295, my lord.
Yes.
In the middle, my lord, I am reading the regional office of the bank vide letter such and such, as already the letter which I have referred, 2010-2005 and letter 112-2005 advised the writ petition not to sanction any loan without further clearance from their office. It is relevant to mention that he has annexed our letter in annexure P4 of his writ petition, that is of 18/3/2006. He was taking plea that he has been prevented to sanction any loan from on and from of this letter 18/3/2006, but this is not correct. Before that, we have issued already 2 letters which I have.
Where is this letter of 18th March 2006?
18 March 2000, he has annexed in his writ petition annexure P4, my lord.
Writ petition is
Annexure P4, my lord. I'm showing, my lord. My lord, allow me some time.
Annexure P4.
P4.
Page 79, volume 1.
Page 79.
Page 79, volume 1.
Yes. This is the letter in continuation of the earlier letter issued in the year of 2005, which I have annexed in my affidavit in opposition, which he intentionally omitted, my lord, in his writ petition.
Shall remain suspended. ওই 21 বার ওই চিঠিটাতে ওই গল্পটা হচ্ছে। Yes, which further paragraph you are saying?
Yes, my lord, in page number 296 of my affidavit in opposition, paragraph number 19, my lord. 296. Paragraph 19. I am reading in the in between of the writ petitioner has sanctioned a loan of rupees 3 lakhs to Mr. Bolai Ghosh on 16/7/2005. The said Bolai Ghosh was an employee at the jewelry shop of Mr. Brindavan Ghosh, staying with him. He did not have any independent business and have no credit worthiness. Hence, the sanction was for non-existing unit. And my lord, similar in the case of Srimati Putul Ghosh, to whom a working capital limit of rupees 5 lakhs was sanctioned, who has no business activity nor any credit worthiness. Similarly, it was the 2 instances. Similarly, he has sanctioned one after another loan who has no credit worthiness, who have no independent business in that area, but loan has been sanctioned even after the restriction imposed by him by the circle office. And my lord,
now kindly come to page 360. How he has dealt with this allegation?
Yes, 360. Yes.
The allegations in got it? Second
Yes.
line. Allegations. Please place that. Allegation in paragraph 19. Brindavan Ghosh and his family charge sheet, but in the dismissal order it was mentioned Brindavan are non-existing borrower.
Yes. Brindavan Ghosh and his family in the charge sheet, but the dismissal order it was mentioned that Brindavan Ghosh and his family are non-existing borrower. But reply available in the dismissal order and 19/8/2008 that the Brindavan Ghosh and family was existing borrower and credit extended in favor of the since 2003 prior to the posted to the branch manager Bhavan Bati post office. My lord, that document neither he produced before the during his.
He says that for easy and credit extended prior to and is but reply available in the dismissal order. Now let us come to the dismissal order 19th of August.
Yes.
19th of August 2008.
Yes.
That is page 496.
Yes.
That fact পরে তো ছিল লোনটা পরের পাতায় যেগুলো দিয়েছে
এইটা হচ্ছে লোন এটিএম ছিল সিন্ডিকেট ব্যাংক চলবে
Mr.
498 meeting.
তখন তো ATM ছিল
দশের পর অক্টোবরের পরে
এটা বলছে SOD jewelry sanctioned and released by the then manager prior to withdrawal of the sanctioning power as per charge sheet. Prior to কি করে হবে 31/10/2005 দিয়েছিল
এইটা কি ব্যাখ্যা
And my lord, though it is stated here, my lord, there is no loan number was specified. It may happen also, though I am not sure that similar name one person has been issued a loan prior to that. It may happen. Though at present I don't have any document in support of my submission. I am from my experience I am saying, because there are similar name and loan are being sanctioned, the specific loan account number and the date should be required for clarifying whether actually the same Bolai Ghosh has sanctioned loan in the year of 2003 or not. My lord, for that purpose, my lord, the document should be perused. Without perusing all the documents, I cannot make any.
How can you make? It was incumbent upon your disciplinary authority.
Yes. Now, what he has replied, that about 2003 it has been done.
So that is why we are asking you, was this point dealt with in the charge sheet?
Yes, my lord, all the thing has been dealt, but I have not in detail gone through the charge sheet, my lord. For that purpose, my lord, I have to go through and I will be able to reply.
Sufficient time, Mr. Pal.
My lord, what your lordship asked on that day regarding the provident fund, that document I collected.
Oh, we were hearing the main.
Yes, obviously.
Now
And now this thing has.
Is with you.
Yes. And
show us that anywhere this point was discussed. Acha, we will question. You proceed in your own matter. What else you want to show us?
Yes.
Now come to the show cause. What is your stand as regards? Show us.
Yes.
You have taken us to paragraph 19. Any
Yes,
other
yes.
paragraph you want
Yes,
us?
another paragraph, paragraph 24, my lord, page 298, my lord.
Yes.
Paragraph 19 of his writ petition. It is evident from the writ petitioner who admit the charge as mentioned in the charge sheet that he has transferred what I have just submitted, rupees 1 lakh from his account to the savings bank account of Brindaban Ghosh by check number 484585 dated 18/11/2005. This action was totally illegal, irregular, and contrary to the syndicate bank employees conduct regulation. And my lord, after that, regulation 15 of the syndicate bank officers employees regulation on 1976 put restriction on the officer employees with regard to their families and lending borrowing. Subsection 4 of the regulation specifically prohibit an officer employee inter alia from lending money in private capacity to constituent of the bank, my lord. And my lord, coming to the very next page, 299, I submit that there was complete compliance of principle of natural justice. The writ petitioner was given the opportunity to conduct cross-examination of the bank witness. The writ petitioner was supplied with all the copies of document in which the charge sheet was based, and the same were produced in the departmental proceeding in presence of the writ petitioner. The inquiry was conducted as per the rules and norms of the bank. After the same was completed, the petitioner was supplied with a copy of inquiry report of the disciplinary authority, and submission, all these submission put forth inquiry proceeding was duly considered, and disciplinary authority became before imposing the punishment of dismissal, committing gross misconduct, the contrary of all allegations are denied. And that is the thing. And the next, my lord, paragraph 28, the petitioner was
Kindly come to para 27.
Yes.
Last two lines.
Yes.
As a result. Got it?
Yes.
As a result,
as a
bank sustained financial loss.
Yes.
It is relevant to mention that overdue and unrecovered amounts are clear loss so long as the bank does not get its money back.
Yes.
What is that amount? That you could not take it back. Because
at present,
no, there are two aspects.
Yes.
One is you are saying that the loan was sanctioned without having any permission under the law. Secondly, he was given opportunity of hearing. He cross-examined everybody.
Yes.
Appeal court should not appreciate the evidence.
Yes.
And third is that there are materials on record to show that loan was also sanctioned who were not even the borrowers.
Yes.
This is your argument.
Yes.
Now, after the dismissal of the statutory appeal, you issued a show cause notice for recovery of the loss of the bank. What was that loss? We want to know. He cannot say.
No,
he cannot say what was. You show us.
Actually, the amount is not in any.
No, Mr. Pal, you are the arguing counsel.
Yes.
You have denied him the provident fund benefits.
Yes.
Relying upon regulation 18 and 19A of the regulations, which you will place.
For the argument's sake, even if in the rupees 1, that is also an offense. That is also an offense.
That is an offense for which his order of the disciplinary or his termination order was good.
Yes.
We are not on that.
Yes.
You're saying even if you have taken 1 rupee,
Yes.
that also tantamounts to misconduct.
Yes.
We are wanting, you have issued a show cause thereafter that we will not pay you the provident fund amount. Why will I not pay you the provident fund amount? Because the bank has suffered a financial loss. You show us the financial loss.
My lord,
Because
he has stated in his writ petition to the tune of rupees 83 lakhs was recovered out of 1.20 crore. The balance amount yet to recover. That is already he has stated in his writ petition.
Show us that.
My lord.
Finish with your affidavit in opposition. Anything else you want to
Yes,
show?
yes. My lord, the petitioner was paragraph number 28, which was I was referring. The petitioner was in duty bound to act within the power, followed a usual undertaking, usual banking norms to prevent financial loss to the bank so as to violate the mandate of the regulation 3 within bracket 1, read with the regulation 24 of the syndicate bank officers employees conduct regulation. That is also I have annexed in my and further the code, the mode of disbursal of loan mentioned by the petitioner was not a procedure restrict to petitioner branch only by for the entire network of the branch, which is hence the allegation of the petitioner of, he has alleged that there was some pressure of the higher authority to sanction the loan, and that has been categorically denied. The allegation that petitioner was pressurized to conduct loan melas and other. This is the statutory thing. All the banks organized to sanction loan, but that doesn't mean that bank will sanction loan violating all the procedure of the banking rules.
The loan mela was in the presence of your AGM.
Yes, yes, we are not denying that.
So if your AGM was the presiding officer,
no loan mela. What I am submitting, the loan organizing loan mela, it is not a credit to the petitioner of the all the bank branch head and all the branches are organizing loan mela to inform the people that we are going to sanction loan subject to the compliance of the formalities. That is the thing, subject to the compliance. In presence of AGM, loan mela organized. But AGM never instructed him the violating all the procedure you sanction the loan to the people. Loan mela as a guest he has attended that loan mela. We are not denying that thing, and it is not organized by the petitioner alone. All the branch heads are organizing. Even nowadays, very frequently, all the banks are organizing loan mela for a certain period to giving loan to the interested person. But during that time, the loan should be sanctioned by following the procedure, not violating all the procedure. That was my submission.
All right. Now, let us. What have you said in your opposition relating to the 2nd July show cause?
He has mentioned my lord, which paragraph you are asking, my lord? He has mentioned show cause in his writ petition.
Where is the writ petition number?
The petition is the volume 1, my lord. 95 to 254.
So you filed the supplementary affidavit annexing the documents in terms of the appeal court order?
No, my lord, read court order.
Read court order. Honorable read court order.
No, appeal court said that you can put in the documents which were not there.
That included in the
Paper. Acha, Mr. Pal, kindly come to the writ petition.
Yes.
Writ petition, he has said about the 2nd July. That is at page 159. Yes, 440, paragraph 4. Show cause notice dated and thereafter one reply was given.
Paragraph 4.
Of the writ petition.
Yes.
Show cause was 2nd of July 2009.
My lord, I am coming.
Second of July 2009. And to this reply was 2024 July 2009. But after that, you did not pass any final order. Now, in your opposition, did they pass any order after that?
My lord?
After the show cause reply you gave, did they pass any order on that?
After show cause? No.
They did not.
No order passed.
My lord, though not specific denial, but it has been stated in my paragraph number 11 that bank has duly considered the reply submitted by the petitioner to show cause notice issued like this, but there was no such specific thing.
Very. Now, where is that show cause? That is at page 100 and annexure P4.
Annexure P4.
Show cause.
Just a minute.
That is, you said annexure P4, no? পেজ 80-তে না? আর 24শে জুলাইটা কোথায়? That is pages 80 and 81. Place the show cause.
Yes.
You have not mentioned in your show cause. Have you mentioned in your show cause what was the amount? You said sustained financial loss of 102 lakhs. That is page 81, penultimate paragraph.
Yes. It is now, therefore, you are called upon to show cause as to why the sum of rupees has been payable to you, management provident fund in terms of rule authority. My lord, there is no such specific matter.
Reply the college page 80. Tangible loss. Acha, where did he say that 83 lakhs was recovered?
In his writ petition, he has stated, just a minute.
Can you show us that, Mr. Biswas, is it true?
83 lakhs, but in support of that, there is no evidence at all. Kindly see, Lordship, the page 257, paper book number, volume number 2. Volume number 2.
250?
57. My lord, 257. Volume 2.
200 supplementary evidence.
Month.
Page?
257.
Where have you stated?
Paragraph, last paragraph.
Last paragraph. Therefore, thereafter.
No, Lordship. Similarly, in the other hand, Deputy Manager P and disciplinary authority submitted charge sheet alleging the illegalities for extension of credit facilities during the service period June 2005 to May 2006 by depositing the bank's huge fund to the tune of rupees 102 lakhs of the risk of loss. But no absolute loss. It is necessary to mention here that the petitioner extended loan facilities to the existing units which is already been recovered of rupees 86 lakhs. 86 already recovered. Lordship, and the another locker in the year of 2008, their central government already published for waiver of agricultural loan 2008 in respect.
Take yours. You wanted to know that portion. Yes. Yes, Mr. Now kindly show us the regulations on the basis of which the show cause notice was issued. Your show cause notice is at page 100, page 80. Right?
Yes.
This was in terms of regulation 18 and rule 19A of Provident Fund towards financial loss. Where are those?
Yes, my lord. Yes, my lord. My lord, sorry, I have the only one copy, my lord.
Is that?
Provident Fund rules.
That you have not annexed here?
No, my lord, your lordship directed me last day, my lord.
Show us where are the regulation. Some regulation you have annexed here. In the in this paper book, you have annexed one regulation. Yes, Mr. Biswas?
Yes.
That is page?
Page, my lord. We have this. Officers regulation, the page 318. The Syndicate Bank Officers Employee Discipline and Appeal Regulation 1976.
380.
Start from 308, volume 2.
308. 8.
My lord.
What are you annexed? They annexed.
308. Volume
yes,
2.
We have annexed.
Yes. Achha. Then first place regulation.
Yes.
18.
Yes.
Right? 18. No, এটা rules. Provident Fund rules. এটা হচ্ছে regulation.
এই ওয়ান আর 24
এই যে শোকজটা ইস্যু হয়েছিল
ওইটা হলে এইটা 80
এই দুটো বলেছে
এটা
রেগুলেশন 80
এটা প্রভিডেন্ট ফান্ড ফর ফিচার
সেইটা রুলটা
এই
রেগুলেশন 80 টা রুল 80 ও Was actually some seven. Yes. Page 150. And one life. Page 80 to 84. আর annexure T4 এর page 82 page 83 তে এসো। পুরো realize করবে। This financial loss. এবার was considered representation of mercy member. The representation আছে দেখো রিট পিটিশনের রিপ্রেজেন্টেশন page 232. Yes, anything else you want to say?
No, my lord, as per your, oh,
We wanted to know, Mr. Pal,
yes,
that your withholding of provident fund amount, you have not passed any final order. Your notice was 2nd July 2009. He gave the reply on 18th April. Thereafter, no order was passed because the writ petition came up for hearing maybe by that time.
maybe.
But Mr. 1918 and 19A says that there has to be an actual loss.
Yes.
Because his provident fund due is about 18 lakhs. Koto? Your provident fund amount is how much?
Provident fund there is the 6
6
lakh
6,000
something.
6 lakh 20,732.
So that is banker's contribution.
Yes, other portion has been paid.
Other portion paid.
Other portion paid.
Employees
Employees portion has been paid.
bank contribution.
Acha, show us that show cause notice at page 8, page 114, na 80 to 84. So this amount of 6 lakh is banker's share.
Yes, that has been withdrawn as per the provision. Other portion has been paid.
So this is bank's contribution.
Yes, bank's contribution, employees contribution has been withheld.
Employees contribution paid.
Paid.
Not paid. Adjusted with the house building loans. This bank also extended the house building loan in favor of the bank manager. That amount, the employees' contribution adjusted with this house building loan, not issue in cash. At the crucial time, with the poor hard situation, they are not issue in cash, in check, in favor of this employee.
As there was due, that has been adjusted, and there is no illegality or irregularity.
Mr. Vishwas, where is this statement of adjustment? Have you said that anywhere?
No.
Lordship, this is my reply. In my reply, I am.
Achha, anything else you want to?
My respectful submission, Lordship, kindly here.
The house.
Kindly allow me.
We are allowing him for so many days. Yes.
In very summary, Lordship, kindly allow me to just a gist of this thing.
Yes, we will allow you. Yes, Mr. Pal, anything else you want to show?
No, my lord, this is the thing, my lord. My submission is that he has allowed and provided from so all the documents, all the allegations against him that has been proved, and he has replied also, and he has admitted in his letter that he has done some mistake, which has been stated in the unconsciously he has made some, that is the stated in the writ petition itself.
Admitted the mistake where?
It has stated in the writ petition, my lord.
Was that?
Yes, my lord. My lord.
Mistake in respect of this technically.
No, in reply he has said he was pressurized.
That has been denied.
Political conflict. There was political
Mistake
conflict.
in respect of the technicality.
But that is mistake.
Show us that. Show us that portion. Writ petition where he has said it. Writ petition starts from page 95.
Yes. হ্যাঁ আপনি বলুন তাহলে জানেন যখন আপনার পিটিশন আপনি তো জানবেন
Where have you stated, Mr.
Allow me that time.
No, please show us that portion then.
Lord.
Do you know that paragraph where you have stated mistake?
In the reply of the charge sheet, I am already admitted that some technical mistake already
Where
committed.
is that? In your reply to the charge sheet.
Charge sheet.
Reply to the charge sheet.
Reply to the charge sheet. Lordship, that are the page 410. এটা এবার উনি বলছেন কিনা সেটা কি করব? No malified intention.
Yes.
But you kindly see the last paragraph, page number 416. Paper book volume number 2. এটাই তো বলতে চাচ্ছেন?
Yes.
No, that you have stated at page 410 in the first paragraph.
416. Kindly see, Lordship.
416, yes.
The last paragraph. This is the admission.
Yes.
The technicality. There is no malified intention. আচ্ছা, আর কিছু আছে?
That is the technical thing against. Yes, my lord, his admission was there that he has done some mistake, knowingly or unknowingly, whatever it may be. And my lord, all the documents has been handed over. He has given an ample chance. He has replied. He has issued a letter for reconsider, which there was no such provision, which I have stated in my affidavit in opposition. My lord,
where is the order of punishment? Disciplinary authority order, punishment order. Is that at page 500?
Lordship, these are the disciplinary order dated 19 August, page 496.
496 to 5.
Page 4, last page is page 500.
500.
So regulation is annexed, you said at page?
Three sub-regulation 1.
307.
Three sub-regulation 1 of 24, read with 24 of Syndicate Banks Officers Regulation 1976. This is the punishment. They are the last.
307. They have applied regulation 31, read with 24.
24.
So what are the punishments? Show us the punishments.
Dismissal from service.
What are the other punishments?
Other punishment, in the major punishment, there are also in the above there.
Was that?
In the syndicate banks regulation, kindly see, Lordship.
সেটাই তো দেখছি
Lordship, kindly see the page.
Where are the punishments?
Punishment. There the page 320.
320.
320. And there the major punishment, their list of major punishment. There.
এটা হচ্ছে সিন্ডিকেট অফিস কন্ডাক্ট রেগুলেশন 76 দুবার করে অ্যানেক্স করেছে। Yes, 320.
There, penalty. Major punishment, the compulsory retirement. The major punishment, there the compulsory punishment first. Second, removal from service, a compulsory punishment, a removal from service, which shall be disqualifications for future employment. And third, dismissal with shall ordinarily and disqualifications of future employment. This is the three. First one, compulsory retirement. First. And the penalties of these minor punishment.
We are not on mine. You have been imposed the punishment of termination. The highest punishment.
These are not appropriate with this misconduct.
Anything else? Anything else?
Yes, my lord, in this regard, my lords, I am referring to judgments of Apex Court, my lord.
Just. Acha, Mr. Bishas, you placed reliance upon certain judgments.
My lord. Four judgments.
আচ্ছা সেটা আমি দেখতে পাবো। Yes, show us which judgments here.
Yes, my lord, it is 2020 SCC online, my lord, page 9.
2020.
Yes, SCC online, Supreme Court, 954. My lord, that is 3 judges.
954.
Yes, my lord, 3 judges judgment. My lord, I am giving the copy.
ভয় দেখাচ্ছে। এই সেটটা ওনাকে দাও তো। Mr. বিশ্বাস, did you refer to these judgments? Please check up. Did you refer to these judgments? Please check up.
Yes, my lord, in paragraph 12 of that judgment, my lord, I am just reading, my lord. It is well settled that the High Court must.
This is a settled proposition.
Yes, my lord. I am just.
Paragraph 12.
Yes, my lord.
Anything else you want to show? It is a well settled proposition.
Yes.
That we cannot act as the appellate authority.
Yes, as a review, as a reviewer.
As a review, and we cannot reappreciate the evidence.
Yes, my lord, my lord.
Fiction is very narrow.
Yes, in under Article 226 Constitution, the High Court shall not reappreciate evidence, interpret with conclusion of the inquiry. Same has been conducted in accordance with law. Next is go into the adequacy of evidence, go into the reliability of evidence. Next is interfere if they
forget one thing, Mr. বিশ্বাস, you have been paid the gratuity. Gratuity you have been paid.
Gratuity?
Huh?
Gratuity paid for it? No, gratuity not paid.
Where have you stated that gratuity not paid? Gratuity not paid.
Gratuity also forfeited.
That is not the stand here. Termination হয়ে থাকলে তো gratuity forfeiture হবে।
To manage
contribution to the year.
You have been terminated.
Gratuity not paid. I am asking.
Because what does the gratuity act says? If you are terminated, then the position will be otherwise. Yes, paragraph 12. Anything else?
And my lord, it is paragraph 13. It is, I'm just reading. Interfere if there is some legal evidence on which findings can be based, correct or error the fact, however grave it may appear to be. Next is go into the probability of punishment unless it shocks its conscience. So everything is there. I am relying on
other judgment.
Yes, my lord. Yes, my lord. And there is another judgment. I am just referring.
Payment of gratuity act done out. Payment of gratuity.
That is of 2011 10 SCC 249. My lord, State Bank of India versus Ramlal Bhaskar. My lord, these are the two.
Paragraphs.
Yes, I am ref. My lord, paragraph 8. Thus proceeding under Article 226 of the Constitution, High Court does not sit as your lordship told, appellate authority over the findings of disciplinary authority, and so long the finding of the disciplinary are supported by some evidence, the High Court does not reappreciate the evidence, come into a different or independent findings on evidence. This position of law has been reiterated in several decisions of High Court, which we need not to refer. My lord, it is known to your lordship, my lord. Yes.
Thank you. Yes.
My respectful submission before your lordship, the branch manager of Bhavanibati branch was the branch manager of Syndicate Bank, was dismissed from service illegally, and the punishment imposed by this authority concerned, that is not appropriate with this misconduct. First one, lordship, there is the 5 charges. The first, second, third, and fourth charges related with this only for the livestock development extension of the livestock development credit. That is not the credit, that is livestock development, that the beneficiaries to the, not the borrower, to the agricultural loan, to the, on the basis of the Supreme Court, the Reserve Bank guideline for extend the agricultural credit. So the then GM personally handed over, distributed to this passbook through the beneficiaries. All the 1, 2, 3, 4, that 4 charges relating to this agricultural loan, that is livestock development. The amount is, I already mentioned in this loan sheet, the amount is 11 lakhs, 5,33,300. That the 1, 2, 3, 4, 5 livestock development loan. First. The second page, first. That the 1, 2, 3, 4, 5, 6.
Those are which were livestock.
Livestock. These are the livestock. That is the livestock development. This, kindly see, Lordship. They are this.
Which one? Which one is livestock loan?
They are in the sheet, in the chart sheet. They are reflected from the chart sheet. I already computed here.
Right. Which is the livestock loan you are saying? All the loan was livestock?
No, all the loan, not all the loan. Only
One
the
was
6.
dairy?
Only dairy loan. Only the 6. That only the 6. That 6 is dairy loan. And the
6,
4.
only which 6?
6. These are the 6 second page. Not first page. 1, 2, 3, 4, 5, 6.
These are what loans?
Dairy loan. These are, kindly see, the dairy loan sanctioned at Loan Mela, arranged on 24th February 2006.
Yes. So your contention is charges 1 to 4 relate to these dairy loans.
Dairy loan. All these dairy loans. I am satisfied before your Lordship. And the last charge, that is the extension of credit facilities, tune of rupees 102 lakhs after withdrawing the sanctioning power. That is the only adjudication when the sanctioning power was withdrawn. That is the Honorable Court, only the adjudicating power, only adjudication issue is that where the loan sanctioning power of the concerned bank is withdrawn. Kindly see, Lordship, they are the documentary evidence. Kindly see. They are the in documentary evidence, page 71, volume 1. They are the one letter, 20 October 2005. Second letter, 7th March 2006.
71.
7.
Page?
Page 78. My lord, page 78. 78, 77 first.
These are of 2006.
No, 77, page 77, 2005. 20 October 2005.
77.
2005. These are the first letter. And second letter on date is very, very remarkable. 7th March 2006. And the loan sanctioning power of this manager withdrawn. In documentary evidence, it was admitted. And in the charge sheet and the disciplinary procedure also admitted at the time of the cross-examination. That is the 18th March 2006. Kindly see the page 79.
Kindly come to page 77. Non-submission of AB 1026 subject.
Lordship.
the month. What is AB? This is appraisal, I think.
That is a statement in respect of the
So
extension.
this is of the month of June, July, August, and September.
June, July, August, September. July, there is no extension. Then the July, June, there is the 16, August 24, September 58. They prior to that. That is not the related to that.
Read the letter. What is written in that? Your immediate attention is invited to telephonic discussion. You informed following information loans during the period June, July, August. It is a matter of great regret so far. You have not submitted AB 1026 AR Atto for the months mentioned above. You may be aware those monthly statements are important in credit monitoring as per guidelines. But you have not cared. In view of the, we advise you to submit such and such along with process notes in respect of loans of more than rupees 1 lakh in person on 24/10/2005. Failing which the matter will be accordingly. Again, you are instructed not to sanction release further loans until we accord clearance for the purpose. So this is of October 2005.
October 2005.
Now the last set of loan which was given to you are of the period of December 2005.
December 2005. Lordship, December 2005. But the loan is not this. The break.
Kindly come to the loan. Second page, that jewelry loans which you sanctioned.
Jewelry loans, December.
December 2005.
December 2005.
Right. So you were restrained. You were said that you do not disburse.
You are restrained, Lordship. Kindly see, kindly appreciate that it is not the break of this card. The process, only application already processed. Already.
Will you process, Mr. Vishwas?
But when withdrawn, when they suspended, my sanctioning power was suspended on the 7th March 2006. Prior to that, but this application is already processed.
Kindly come to page 78. Page 77 said you have not given AB 1026. Now page 7th March 2006 letter. Now what is written? Upon review of reporting registered AB 10, it is observed that you are in the habit of sanctioning various credit facilities without following the basic norms. Please note, matter has been viewed seriously and advised us to inform you that your sanction to grant shall remain suspended. So you were suspended since October 2005, and this letter is in continuation.
Not October 2000. October 2005 only warning, only the warning, only the request.
That is your argument. That is your argument. What is the your sanctioning powers will continue to remain under suspension. Then what does it mean? There was a prior restraint upon you. Mr. Vishwas, suppose you have
in this order, Lordship, kindly see there the reflection that after withdrawing your sanctioning power, you are extended 102 lakhs amount. That is the main grievance. So here, when this loan sanctioning power was withdrawn on 18th March 2006.
Where?
18th. So thereafter.
Read 18th March letter. Read page 79.
18 March, kindly see this 18 March. Page 79. There has been report to the gross violation of the credit norms and guidelines in sanctioning and the post-sanctioning follow-up of these loans on advances in your branches during the period of your tenure in this branch. We had conducted a review of these advances of your branches by the distributing officers from our office, and then subsequently you are consulted in a persons with these followings to relate down guidelines in this matter of the credit sanctioning and follow-up. Hide our letter dated such and such, the 1st December 2005, you were advised to exercise restraints and seek prior clearance with sanctioning fresh loans. However, the fresh advances continue to be granted by you without seeking prior clearance from us. Finally, a team of the 2 officers comprising the chief manager credit and the 1 group headed was again deputed to our branches and conducting investigations about this loan and advances granted by you. Now, upon going through this report, it is decided that the further exercise of delegating loan sanctioning power by you will not be the interest of this bank. I therefore, in accordance with this power conferred on me via the circular number such and such, withdrawing the loan sanctioning power delegated by you in terms of this credit sanctioning.
All the four charges related to DRE loan.
My lord?
All the four charges, first four charges are related to DRE loan.
DRE. All these charges are there. They are non-existing. No adjustment. That is the adjustment technicality that are also over these others. That is a technicality. The adjustment. These are the social worker. He also adjusted, rested the NPA by one account to one account. No. These are the just like work as a social worker. The higher authority advice restain the NPA. That also one account to another account. They are also restraining NPA. There is no malified intention. There is no illegality. He was awarded. I am representing before your lordship. He was awarded in the year of 2005. He exceeded the parameter. I am submitting. Lordship. So it is two very important point is that when the sanctioning power was withdrawn by this manager.
Where is the chart sheet? Please give us the number page.
Kindly see this language. Page 260. 260. Kindly see this language. Volume 2. 260.
Why do you say all the charges 1 to 4
Lordship
are relating to dairy? Where do we find that?
Imputation of the statement on the statement of imputation. And second thing that on the basis of the fifth charge, there is no the statement of imputation in the charge sheet. No. My learned friend kindly satisfy before the honorable court. There any imputation in the fifth charge, and that's why they are mentioned in this order sheet as well as the charge sheet. There is a risk of loss, not the loss, sustainable loss.
Where is the fifth charge?
Now the fifth charge, Lordship, kindly see the 260 page.
260 articles of charges.
Lordship, here there is a charge sheet that the charge is, fifth charge is here. That is.
Where is charge 1, charge 2, charge 3, charge 4? Where?
Charge 1, first, Lordship, there is 1, 2, 3, 4 not mentioned. They are mentioned here. First charge is that. Lordship, kindly see. This first charge is in the process, that the page 259, first one. Lordship, got it? In the process.
Where you are reading?
The articles of last 1, 2, 3, 4, 5 lines, 6 lines, above 6 lines. In the process. In the process, you extended credit facilities to non-existing units in connivance with middleman. That is the first charge. Second charge is placed on record false post-sanction inspection report. Second charge. Third charge is sanctioned a loan of rupees 1,10,000 in the name of a party without his knowledge and misused the loan proceeds of yourself. This is the third charge. And fourth charge is made several unauthorized adjustments from one account to other accounts, including your own accounts. This is the fourth charge. And the fifth charge is sanctioned credit facilities to the tune of rupees 101.86 lakhs, even after withdrawal of your sanctioning power by regional office. When the regional office is, in respect of the fifth charge, language is very clear. When the regional office is withdrawn the sanctioning power, that the disciplinary power of this branch manager, when that is not adjudicated by the disciplinary authority, not adjudicated by the appellate authority, again and again, this is a manager, they have stated that I am not extending any credit facilities after withdrawing my sanctioning power, again and again.
Then you are, why you are distinguishing between the loans now? The chart which you have given,
Lordship.
First one is loan sanction before withdrawing of loan sanctioning power as per chart sheet. Which are the dairy loans? Dairy loans are only to the tune of 5,33,000.
Lordship.
And jewelry loan was to the tune of 11,81,000.
My lord.
So according to you, the withdrawal was on 18th of
March 18 March 2006. It, as per the documents, not my representation. As per the documents, the concrete evidence, and suspended on this 7th March 2006. If I consider the 7th March 2006, prior to that, 7th March 2006.
No, not October 2005.
No, not October 2000. They are suspended on the 7th March 2006. My sanctioning power is suspended, but there is no power by the chief manager. Only the deputy general manager is withdrawn my sanctioning power. That disciplinary power only withdrawn by the deputy chief manager. They are also there. That letter is no legal viability at all. No right, chief manager.
Come to page 77.
77. 77.
Page 77 is in respect of loans for the months of July to September.
July to September, that is another thing.
First, explain to us.
Lordship.
From the letter, it appears that you have been informed in respect of loan sanction during the months of July to September.
Lordship, that is the
July to September 2005. You have sanctioned loan to the tune of more than, this is how much? This is in lakhs, 22 lakhs, 50
2 lakhs, 2 lakhs 1.
No, 22 lakhs from 04.
22 lakhs 02.
Then 50 lakhs. Then 128 lakhs.
Yes.
This March in September to this chart which you have given, this does not tally with the statement.
No, there is no allegation in the chart sheet. This loan to prior to that, only that allegation, that not in the chart sheet, that is allegation. In the chart sheet, that loan is that in respect of this loan, there is any allegation in the chart sheet. I am computing this sheet from this chart sheet. This is the loan.
Where from did they find that the loan amount was
I am
102 lakhs?
102 lakhs, they are already reflected in this order, in the chart sheet. And they are the loan number, they are the beneficiary's name, and these borrower's names already reflected in the chart sheet.
Where show
From
us?
the chart sheet. Kindly see the Lordship, kindly see the chart sheet. Kindly see the chart sheet.
That is
page 390, 387 paper book. That all the names and this amount are already available. First one, Lordship, kindly kindly mark in this letter, my computation sheet. That the first one, Ziaur Rahman, that the 21st January 2006. 21st January 2006, loan was sanctioned. There 98.
12ই June 2007, দু জায়গায় annex করেছে. You have annexed it at page 259 also. Chart sheet.
No, my lord. But this charge sheet I am not marking.
Hmm. What you are showing?
But I am showing the 388. Lordship, that all these names and this amount are also available in the chart sheet. From the chart sheet, I am computed in this sheet. The when amount they were credit sanction extended and the amount, their beneficiary's name and their account number, all are reflected. Kindly see, Lordship. The statement of imputations of your part. Kindly see the first one, the Ziaur Rahman. Ziaur Rahman. The next second page, my computation sheet, second page, the DRE loan. Ziaur Rahman. They are 98,000, 24 January 2006. Lordship, tally with my. And second, Lordship, kindly the two, the Firoza Begum. The 24th February 2006, 24th February 75,000. And third.
So these are in respect of DRE loans.
DRE loan. All these loan, I am satisfied before I.
And it is up to now. Kindly come to
Lordship.
So the DRE loans were one to Ziaur, other to Firoza, third to Mahadev, fourth to Introjit Ghosh, next Ahsan Ali, and next to Bhutnath Ghosh.
6 Bhutnath Ghosh. Lordship, kindly
DRE loans.
They are complete. And second, Lordship, kindly see the second, first page.
Second, yes.
Second, first page. The Bolai Ghosh.
Bolai Ghosh. This is in respect of in the matter arranged to various members of Ghosh family at the behest of Brindaban Ghosh and Tapan Ghosh.
Lordship, kindly Bolai Ghosh.
Now this Bolai Ghosh loan was given to whom?
Bolai Ghosh 2004 on 2004, but here it was sanctioned or said. Lordship, these are also Bolai Ghosh. My learned pet already alleged against that. But it was the existing in that 2004, they are operating in the said banks. Lordship has been operating. Lordship, kindly see this 25th May 2004. Here, 25th, the Bolai Ghosh. And second, they are only the overdrawn allowed in respect of this loan, the 3 lakhs on 16th July 2005. Lordship, kindly see Bolai Ghosh on 16th July 2005, 3 lakhs. All these things are I computed from the chart sheet. This loan, all these loan, 91 lakhs from the chart sheet there. And third loan, the jewelry loan from the chart sheet. They are the loan. But the disciplinary authority, no imputation, statement of imputation in respect of the 4 charges. That is the order of the disciplinary authority.
Which 4th charge?
5th charge. The sanction of 102 lakhs after withdrawing the sanctioning power.
Yes.
After withdrawing the sanctioning power, there is any imputation in the charge sheet. Lordship, there is no imputation. Kindly see in respect of the 5th charge. There is no explanation, no statement. The Sas and Sas account, in respect of the Sas and Sas account, you already extended credit after withdrawing your sanctioning power. In this syndicate banks regulation, kindly see, Lordship, syndicate bank regulation, kindly see.
Now this one, then 101, this 5th charge, this is pertaining to which loan in your chart?
No, total. The jewelry, DRE, and all these loans. My adjudication is that the charge sheet, my allegation in respect of the 102, that 102 in respect of all these charge sheeted loan.
As per charge sheet total amount, but total loan amount sanctioned.
But that is not to tally with this. That the 108.14300. The calculation also wrong.
What do you mean by this? As per the charge sheet, total amount is 102.86.
They are.
But total loan amount sanctioned by manager prior to withdrawal of loan sanctioning power. is 108 more than that. So your argument is that the fifth charge has not been established.
Not established, no explanation at all. But in respect of the charge, kindly see this regulation. The syndicate bank officers' regulations and appeal, they are clearly stated that in respect of the each and every charges, there is statement of computation must be, and the copy issued. That this is this loan account, this is the beneficiary, this amount you extended in favor of this borrower. That you are guilty. You are committed wrong. You not extended this credit as per the banks, not obeying the bank norms. This type of behavior not done by this authority concerned. Kindly see this regulation. Kindly see the regulation, Lordship. Kindly see this regulation 308. Page 321. Syndicate Bank Officers Employee Discipline and Appeal Regulation 1976. Page 321.
Yes.
321, paragraph 5. The disciplinary authority shall, where it is not this inquiring authority, forwarded the inquiry authority.
That you have argued.
And prior to that, kindly.
You are now, you sum up your argument. First was, you have argued. Your argument is that the fifth charge, there was no imputation.
Statement of imputation not available in this.
So you cannot hold me guilty of that said charge.
In what way?
So far as the other charges are concerned, there had not been enough evidence to establish that. And it was given in a loan mela in presence of his hired officials. Very good.
So the middleman, if this considered this middleman, that the then AGM, he also the middleman? He personally distributed.
Your
this
AGM
passbook?
will know. Your AGM will
ADM,
know
24.
Your AGM will know. Your AGM will know that you are not having sanctioning power.
No, at that time, 24.
Just because AGM was present, you are saying.
24th February
My lord, I'm
2006.
sorry, my lord. My lord, AGM was invited to attend that loan mela. He attended. Maybe he is not aware of that fact. AGM's presence will not improve his case.
Yes. The judgments which we gave, those were the judgments you are relying upon.
Lordship.
Give us the.
Lordship, second one, very, totally illegal.
Yes, give us those judgments. We shall consider. Give us those judgments.
The four judgments, Lordship.
We have given you the copies just now.
Then.
Just now we handed over. Give all the judgments which you are relying.
All the judgments.
Which judgments you have relied upon.
Four judgments.
Yes, give us.
First,
Yes.
Paragraph 26 and 37.
Judges.
High Court, Calcutta, Dipankar Sengupta and others versus the United Bank of
Paragraphs 26 and
37.
Very good. Next, what is the other judgment?
Reported judgment.
Dalal Project, Bombay High Court.
Yes, show us paragraphs.
Dalal Projects. Paragraph 4 and 5.
Yes.
1, 1, 2. Dalal Project, Bombay High Court. Paragraph 4.
তাড়াতাড়ি দাও
4 and 5.
Next দিতে হলো প্যারাস 4 and 5
4 and 5. And next,
হুম
these are also the Supreme Court judgment, State Bank of India versus T.J. Paul.
হ্যাঁ
Here this paragraph number,
দাও
then paragraph, here the paragraph and of the list copy to the page number 3, middle paragraph, page number 3, middle paragraph, and page number 6, last paragraph, and page number 8, last paragraph.
yes
In the another judgment, the color came limited versus the LK Purkarkar, Aspurkarkar. These are although the paragraph, then এটা
paragraph
the page number 9, last paragraph.
all right
And paragraph number 11, last paragraph.
page 11
Page 11, last paragraph.
thank you Mr.
Lordship, another thing is that without investigation before the disciplinary authority representing all these facts, it is admitted at the time of cross-examination that the two management witness, MW1 and MW2. MW1, that Anilesh Roy, the vigilance officer, another, the Aniruddha Bose, Aniruddha Mitra. The Anilesh Roy, all alone representing before the disciplinary the authority concerned, that this is thing, all these facts, but they not present in this unit, not investigating unit, not investigating any documents, only documents in office, only not investigating the units. These are admitted, that also admitted in this proceeding.
The learned advocates appearing for the respective parties have concluded their arguments. Stop. Judgment.
Lordship, another thing is that the power of this credit sanctioning power of this branch manager. I am one copy I handed over. And
no, don't add documents which are not there.
No add documents. These are the power. The credit sanctioning power. How much power there? Credit sanctioning power. This branch manager having this power. How much?
Your withdrawal notice is not under challenge. It is not a case that withdrawal was illegal. Payment of gratuity.
My lord, before your lordships rise, my lord, the next two matters, 7 and 8. Lord, in the second half, I have some personal difficulty. My learned senior friend is appearing for the appellants. Would it be your lordship's pleasure to kindly take it up tomorrow, my lord? Next two matters, my lord.
Let it be in the list, we will see. You ask here.
7 and 8. Grateful.
All the list.
Your Lordship, I appear for the appellant, Your Lordship. Your Lordship, on the last occasion, Your Lordship directed the respondent to avail necessary instruction, Your Lordship.
Your other side.
Your Lordship is not there, Your Lordship. Mr. Bajpayee is appearing for the respondents, Your Lordship.
Not today.
7. You are for the
Appellant, Your Lordship.
You are for the appellant. Yes. What is the matter?
Your Lordship, this is related to Your Lordship that the letter of appointment under the land loser category, Your Lordship, that is Tarkeshwar Bishnupur. The appointment has been given to one Sudeshna Panja, Subhodip Panja, and Utsav Barui, Your Lordship. But Your Lordship, the appellant was not considered, Your Lordship. This matter was done by Your Lordship, Mrs. Dhabal, Your Lordship. Today she has not come to the court, Your Lordship.
Was there any order for taking what order did we pass?
Your Lordship, the order is, Your Lordship, order dated 29th September, Your Lordship.
We passed an order.
Yes, Your Lordship. We have filed one supplementary affidavit, Your Lordship. In respect of that, Your Lordship directed the respondent to avail necessary instruction, Your Lordship, in the matter.
Yes, show us what is the matter. Other side. Not today, not today.
Grateful, Your Lordship.
Yes, my lord, I am for the applicant.
How about the respondent?
What happened in this matter, my lord? My client was not allowed to resume duty and the salary has been withheld from April 2022.
এটা তো ছিঁড়ে গেছে তো কি করে শুনছি সেলাই করে Yes, tell us what is the
My
matter.
lord, I approach before the honorable tribunal against the order of transfer
Transfer order.
from Kagai to New Delhi because that order was passed without routed to placement committee and also violates the DOPTOM that husband and wife should be posted in the same station. Now, challenging the said transfer order, the tribunal, after hearing both the parties, was pleased to grant a stay and directed them to file a reply. They did not, despite the interim order granted by the tribunal, the respondent did not allow the petitioner to resume duty in the office. For that matter, I filed a contempt petition. The contempt petition was heard out and reserved for judgment on January 2023. 23/1/2023. Now the tribunal has failed to deliver a judgment till today. The status report is there. By this time, my lord, I approach before this court that either to pronounce the judgment of contempt in the meantime, my lord, I may be allowed to resume duty.
Because
You approach the tribunal by way of an application again.
by violation of the interim order, I filed a contempt petition.
Very good. That
The contempt petition was heard out at length.
heard out
Matter
and
was
judgment reserved.
matter was judgment reserved, and till now it is reserved.
Very good. So you have
And
come.
several times I mentioned this matter.
No, no. What is the challenge before us?
Challenge before this matter, last occasion matter was heard at length. On that day, my lord was of the opinion, by directing my learned friend, that at least to allow the petitioner to resume duty, and we close the contempt proceedings. Also, can you remember the Ordnance Factory Board matter? And Mr. Nondi was directed to take instruction why he will not be allowed to resume duty. It was heard at length by your lordship. Now,
Yes, Mr.
Well, the fact remains, well, the entire OA application was heard, judgment reserved. Contempt application was heard, judgment reserved. No, my lord, at this juncture, whether my lord will interfere or not,
Original
that is,
application was also heard.
no, my lord.
it was heard.
Only
My lord,
contempt matter.
no, it was heard.
But
It
kindly
was
see,
heard.
contempt matter has
We
been.
have taken the status report of the original applications.
So as the judgment is reserved, you will not comply with the interim order.
Well, so far interim order is concerned, if your lordship kindly consider the interim order dated 9th September 2021, there, my lord, the tribunal, learned tribunal said that this interim order is valid till filing of the reply affidavit. So the moment we have filed the reply affidavit in the OA application, as well, my lord, the compliance report in the contempt application, my lord, the interim order gets vacated.
You filed a compliance report.
Yes, there.
What compliance?
Compliance, my lord, the tribunal raised.
Was the interim order passed?
Well, kindly come to page 130.
Page 137.
September 2022.
Page 137,
130, I'm going to 130.
137 is last paragraph. The penultimate paragraph is this.
Yeah.
And that order has been extended from time to time.
Extension.
No extension. So the extension.
Now, this interim order was passed on
9 September.
9 September 2022.
And they have
September 2020.
they have disobeyed the interim order.
Sir, Mr. Das, we have heard you. Yes.
Yes. And the last paragraph, paragraph 10 of the at page 137. The operative, this is the operative portions of the order. As such, and penultimate paragraph. As such, let a reply be filed by 4 weeks. Rejoinder, if any, to be filed by 2 weeks thereafter, till such time, comma, the applicant's transfer shall remain state. So my humble submission was till such time means the till the date of filing of the reply affidavit within 4 weeks from the date of passing of the order. So, the moment we have submitted our reply affidavit, interim order goes, or it has come to
What
an
was the interim order?
interim order,
Transfer order shall remain
order of
state.
transfer was state.
Then where he was working at that time?
Sorry,
Transfer order was issued.
On 11th April.
Transfer order was issued on
11th April 2022. At page 72.
Very good.
He was released on the same day. He was released on the same day. Page 72, dated transfer and release order dated 11th April 2022. With reference to the above transfer order, the undermentioned individuals are hereby released and struck off strength of DOCS Kolkata with effect from 11th April 2022 afternoon for joining to the new place of posting. There are 3 persons. Out of 3, only 1 did not join, and my lord, other 2 had joined in the place of posting, transfer place of posting at New Delhi.
So during 11th of April till the date of issuance of the order, he was not joining, he was
No,
not
he was not
working.
working. He didn't join.
Very good. Now, when the transfer order is stayed, then the natural consequence is he should be allowed to continue in that post.
But here is
What was your compliance report before?
Yes,
the
one
transfer?
kindly see the compliance report. May I submit?
That is annexed here.
No. I have come with the compliance report. Kindly put it. Paragraph 12.
So when did you file the reply, Mr. Nandi?
But we have submitted our reply on 27th October 2022 because of puja vacations, 1 day delay in filing. Just on the day of reopening of the court, we submitted.
Now this main original application has been hard out.
It was completely hard out and not CAV. Now, what is the new things to be hard, or this court assume the jurisdiction? My lord, under Article 226 can do that.
What was your complaint?
Kindly ask. Paragraph 12, 13, and 15 are relevant here. Paragraph 12, we said so. Although they are very harshly written by so far the current council is concerned. The paragraph number 10 of the order dated 9/9/2022 is very clear. That is, transfer order would remain set for 4 weeks till filing reply by giving 5 points clarifications, which means that the respondent authority who issued the transfer order will not insist the applicant for joining in the transfer place of posting, but does not mean that the transfer order is withdrawn. Hence, the letter of the applicant to allow him to join in place from where he was transferred is a bogus concept, and it has been imported from a foolish word. The authority concerned cannot allow a person a join in its old place of posting until and unless the transport is withdrawn or quashed.
Is it so? Then what is the effect of an interim order?
Interim order was for limited purpose and limited period also.
No, Mr. Nandi, if this is the language used by your office.
That's why I said so. Before placing my paragraph, I said so. I beg a pardon. So far, this language is concerned, kindly ignore. But paragraph 15 is
why should we ignore it? It is on affidavit.
Affidavit they have filed there.
So they have said that the tribunal has passed a bogus order.
I do not want to say further. What was the very poor drafting? Assuming it's a very poor drafting.
No, this is scandalous drafting.
Right, absolutely correct. I beg a pardon.
You are saying that the letter, hence the letter of the applicant to allow him to join, is a bogus concept.
Absolutely correct. And that's why while I was reading this paragraph, it was touching in my conscience. How do I place before your lordship? However,
how can you avoid Mr. Nandi? Who is your officer?
Officer, whoever may be, but as your lordship knows, the usual practice who draws the petitions and who have, but I do not want to say more. So that is also go against my colleague, one of the.
This is not proper conduct. If this is the view of your officer, then there is no justification for remaining for any judicial authority to exist.
Not required at all.
Yes, in our constitution.
Not required at all. Seems to be.
So he could have said before now you are taking a point that it is a bogus order. I will not comply. Do whatever you want.
No, but paragraph 15 is relevant also. I also consider paragraph 15. That with regard to the statements made in these paragraph 5 to 7 of these contempt applications regarding the contention put forward in this case paras, it is submitted that the applicant along with 2 other Group B gazetted officers holding the post of JWM SG had been transferred from Directorate Ordinance Kolkata to Directorate Ordinance New Delhi with a transfer order dated 11th April 2022. All the incumbents, including the applicant, were released and accordingly struck off from the strength on 11th April 2020 itself. Therefore, the question of allowing the applicant to resume duty does not arise.
How? We fail to understand, Mr. Nandi.
In order to defend the
Then what is
contempt
the-
petition,
No, no, then what is the utility of a superior forum? You have not challenged that interim order.
I have not challenged. Rather,
had challenged.
Opinion was not to challenge, to comply the order passed by the tribunal. There are 5 clarifications short for. We had given clarification in our compliance affidavit, as well as in our reply. 5 questions.
Now, so those were placed before the tribunal.
Yes.
It was hard.
Yes, it was hard.
Where do we find that the judgment was reserved?
But from the
The original application is still
yes, yes.
pending.
From the
Did you file any
status
rejoinder to that? Did you use any rejoinder to
Well, my
this?
learned pen is not correct.
Achha,
Only
we will hear. This is the problem. Yes. When
kindly see the status report taken out from the server of the portal, the web portal. Attach. Case number CP at the top, first page. CP number so and so in OA number so and so. Diary number. And respondent compliance report submitted on so and so date.
no, compliance is in contempt.
Yes, I'm coming. Court case hearing. Contempt at the bottom of the page. Hearing date 24 January 2023. Contempt petition order reserved. And next page, Millard.
Contempt petition order.
Contempt petition. OA.
Page OA 1207.
OA 1.
Pending.
1207. Yes,
Pending.
pending.
The judge
OA
is
1 to pending. A hearing was concluded.
Why?
OA was not heard of. Only contempt is reserved for that.
For hearing, adjourned with direction for being spoken for. Yes, ma'am, kindly see order reserved. Last serial number 1. 13 July 2022, order passed over matter, order reserved. We had taken out the.
What is that?
And see the order reserved. Justice Chakraborty. See the last entry. Last entry. That is the way. Order reserved.
No. This is diary number 1760 or 2022. What is the
এখানে কিন্তু স্ট্যাটাস দেখাচ্ছে পেন্ডিং
OA is pending. No result.
এখানে হচ্ছে অর্ডার রিজার্ভ
Case number.
অর্ডার জাজমেন্ট রিজার্ভ
Case number is there.
Status.
OA number 1207.
Last heard. No. Kindly come to the first page, case status. Pritam Mojumdar versus defense. Filing date 6 July. Got it?
31st July 2023.
No.
No, but kindly skip the first 2
We are
pages.
going to that.
Second page.
Second. No, yes.
No, 3rd page. Kindly come to 3rd page. That is the status report pertaining to OA case.
Come to the 3rd page.
3rd page. I am on 3rd page.
Case number OA 1207.
Yes.
Now, status is pending. Next listed on 31st of July 2023.
Then 13 July 2022, passed over matter in the right hand side status order reserved.
তারপর pronouncement of judgment এর জন্য আবার করে adjourn করে
For being spoken to, for pronouncement of the judgment, final order, and then passed over order reserved.
এটা আগে এটা পরে
এটা তো আগে হয়েছে।
এটা তো সেপ্টেম্বর এটা জুলাই
এটা হলো এটা কি pronouncement?
No, the first page, Mr. Nandi, is relating to the contempt. Now, in the contempt, bottom of the page, hearing heard on 24 January, nature order reserved.
Order reserved.
Order reserved.
13/7/2022
তুমি 24/2013
13/7/2022 তারপর 26/5/2023
That is
when last taken up for hearing next
No,
listed
no, on 24th January,
31st.
so far contempt petition is concerned,
Come to here. You are trying to show 31st July 2022. Then order reserved. Any order, not judgment. Thereafter, 9 September 2022.
last but one, Manoj, can you see the last but one entry? Last but one entry.
13th of July 22.
Last taken up on 13th July.
No, 9 July.
9 September.
Sorry, 9 September. 9 September is the last hearing.
Thereafter that is the date after 13th of July.
Yes.
So in 9th July,
9 September.
9 September, list the matter on 7th November 2022.
For what purpose? For pronouncement of the judgment and final order.
Where is that?
একটু আন্ডারলাইন করে দিন
এটা আমি একটু করে দিচ্ছি take back for a moment to mark it.
Thereafter, again, I would have got it. Again, 26 May 2023, the matter was taken up.
Yes.
Adjourned with direction.
Adjourned with direction
Then
for
again,
being spoken
27
to.
June.
Yes.
27th, adjourned with direction.
For hearing. So once it has been
Then
placed
the
under
matter was
judgment delivered and then adjourned.
directed to be listed on 31st July 2023.
Well, matter is pending. Next date is 5th December.
Last page.
22 এবার এইদিকে 23
এইটা তো তার আগের ডেট
তাহলে এইখানে 23 আছে
From bottom to top, we'll go through in this way.
adjourn with direction 27 June 2023 adjourn with direction
এবার
Yes.
37 31st July 2023
Order was reserved
then come to no order
chronologically.
adjourn with direction.
try to understand 13th of July 2022 order reserved
Lordship.
after that the matter came up on 9th of September 2022
For pronouncement.
acha very good for pronouncement of final judgment
Lordship.
on that date adjourned with directions
Right.
so final judgment was
Not yet delivered.
interim order was passed
Right. On
now
the same.
next date for being spoken to we do not understand
We do not
why.
also understand.
Adjourned with next date is 27 June 23 for hearing. So if it has judgment reserved, why will it appear for hearing?
And that is also doubtful.
I know.
Yes.
Why it will be done?
A little bit of confusion.
37 এ
Little bit of confusion.
31 এখানে দেখাচ্ছে প্রেজেন্ট নেক্সট লিস্ট
না ডেট করলো 31st কোথায়
এইখানে এই যে 31st আবার ডেটটা চলে যাচ্ছে
হ্যাঁ
31st
আচ্ছা
31st July 23
হ্যাঁ সেদিনকে
আবার 31st
কন্টেম্পটে অর্ডারটা
লিস্টেড হয়েছিল কিন্তু
লিস্টেড হয়েছিল সেখানে কন্টেম্পটা অর্ডার রিজার্ভ করেছে ফার্স্ট কথাটা দেখো হিয়ারিং ডেট আবার 24/1/2003 কি বলে বুঝতে পারবো না। এইটাতে দেখো কন্টেম্পটা ফার্স্ট শুনানি হয় 9/11/2022 তারপরে হলো 7/12/2022
May I suggest one thing to cut short the matter?
হয়ে গেল 24 January 2023 Yes, how will you cut short?
Yes. Kindly direct the tribunal to dispose of this main application way as well as contempt applications within a timeline frame. Maybe framed by your
in the
lordship.
meantime what will be
So
the
you ask your officer not to appear before the court. It is not a court. We are having a fun. Your officer says that is a bogus concept.
I appreciate lordship.
So you ask
I
your
didn't
officer,
want
we
to
will inquire.
rely on that paragraph, but I had to rely on because but I can't develop the pleadings which was made.
আমি তার মানে কোর্টে একটা অর্ডার দিই সেই অর্ডারটাই আমি কন্টেম্পটে বুঝে নেবো কি আমার কন্টেম্পট
লিখে কোর্ট ইজ ল্যাঙ্গুয়েজ
তো আমি তার মানে প্রসিড উইদাউট কমপ্লাইং কি রিজনে যেহেতু রিজনটা হচ্ছে যেহেতু সেট অ্যাসাইড করে দেয় not insist. Not insist on joining the transfer company. Stay করলো মানে will insist for joining the transfer company.
কি করেছে?
পিচ করে দিয়েছে, পুরো স্টাক আপ করে দিয়েছে, মনে করছে এটা কেউ ছুঁতেই পারে না। আমরা একদম
এই কথাটা কি ভাবি যায়? সাথে তো দুটো অর্ডার ট্রান্সফার
না, ও মেন
ট্রান্সফার পোস্টে জয়েন করতে পারে। বলে স্টে করা মানে স্টে করেছে সেপ্টেম্বর 2020 বাই দ্যাট টাইম জয়েন করাতে বলি ওই জায়গা তো
সেওরা কি মানে
কিন্তু 2 মাস পরে তো অর্ডারটা অর্ডার রিলিজ অর্ডার হলো জুলাইতে। ও মামলা ফাইল করলো 31st, ওই জুলাইতেই ফাইল করেছে। ট্রান্সফার ছিল
ট্রান্সফার অর্ডার 72
He was released. Page 72.
released and struck off for joining the new
11th April 11th একই ডেটে বাবা একই ডেটে ট্রান্সফার করছে, একই ডেটে রিলিজ করছে। ডেপুটি ডাইরেক্টর ট্রান্সফার করছে, জয়েন্ট ডিরেক্টর রিলিজ করছে।
June 20
ট্রান্সফার অর্ডার হচ্ছে দিয়ে হলো 9/9
by that time
মাইনর দিয়েছে অ্যালাউ।
what is this 13 June 2022 order?
13 June.
Prior to this, he moved another original application.
13 June 22 is a reason order passed by the authority.
So, challenging that he
Earlier order.
First original application was 675.
Yes.
So, that speaking order was challenged.
Yes. Why he should not be transferred? The show cause notice was issued. In the response to that, he had
What is
given
the 13 June
page 110.
page 110.
110.
On the basis of an order passed on 5th May 2022
Lordship,
by the
by the tribunal.
So on that date, was any stay order passed? 5th
No,
of May?
no stay order. Only direction was given within a month to pass a reason order.
এই অর্ডারটা ওরা পাস করেছে in terms of an earlier direction order. But by that order, there was no stay.
Authority was directed to pass a reason order within a month.
They passed the order.
We passed the order saying that your representations we have considered but not satisfactory. Therefore, you have to accept the transporter and immediately join in the transfer place of posting.
No, interim order was passed. Paragraph 4. In the earlier way, tribunal passed the following order on 20th of April 2022. How can that be? Paragraph 4.
Paragraph 4 at page 111.
We are not cleared with the facts. 11th of April 2022 was the order of transfer and release.
Lordship.
Now, he must have made a representation against that.
Against that, my lord, he has challenged 11th May 2022 order by filing OA application.
Which way? No.
That OA application was decided in May 2022
No.
with a direction. Yes, my lord.
To an Kindly come to the 9th September order. In a sequel to an earlier OA, this application has been to seek the 13 July. So first OA was 675. In that OA, there must have been a direction that you considered the representation.
Yes,
After that, in consideration, you passed the order of 13 June.
Lordship.
That was challenged in 675. Now, paragraph 4, that 675 was disposed of saying, respondent shall place on record such and such interim order, if any, to continue till niece date. What was the interim order granted?
My lord is reading from page 111.
131.
131. September, or this is an order dated 9 September 2022, passed in way number 1207. That is para 4. In there is no interim order as such from the pleadings itself. Nine September. Way is disposed of on 5/5/2022. No such interim order. 5/5/2022. What about 5/5/2022? Order date. Right. আচ্ছা। Kindly see the earlier order, page 103. The order passed by the tribunal dated 5/5/2022. Kindly see the operative post. Paragraph 6. 5/5/2022. Against in that order, tribunal directed the authority to consider his representation and pass a reason order within a month. But there was no interim order. Page 103.
99 টা করা 99 interim order আছে page 99. Page 99 interim order.
If there is no coercive action, if there is no coercive action to be taken,
This one.
Therefore,
let the applicant be not released.
if not
Not already released. It's a
So on the basis of this order, page 104.
Page 104.
You passed an order on
13 June
2020.
Yes.
But
Now,
in this, there was no interim order.
Kindly come to page 100. There was an order to that effect. I do not want to say interim order, but kindly come to page 199 and page 100. Page 100, last part 1 paragraph.
Be not be released.
Yes, therefore let the applicant be not be released, if not already released, till the next date of listing. And if released, no coercive actions be taken against him. So he was released on 11th April.
Next paragraph is very.
And respondents to show that the applicant has been served and release order prior to. Yes, we have that we can show. He was released on 11th April, and this order has been passed on 18th April 2022. So if not released, then it would have been given effect to.
10 মিনিটের মধ্যে রিলিজ করেছে সেদিন ট্রান্সফার অর্ডার সেই
না যেদিন অর্ডারটা হয়েছে
যেদিন ট্রান্সফার অর্ডার সেই দিন 10 মিনিটের মধ্যে প্রিন্টটা নিয়েছে
ট্রান্সফার অর্ডারটা তো হয়েছে তোমার
11 এপ্রিল 2022
অর্ডারটা পাস হচ্ছে 18 এই ট্রাইব্যুনালের অর্ডারটা।
হ্যাঁ এটা আছে
কারণ বলছে আমাকে 4 দিন পরে এই যে দেখছো তার আগে এই অরিজিনাল ট্রাইব্যুনাল এতেই শেষ করেছে। ও যে পয়েন্টটা নিচ্ছে না যে ট্রান্সফার অর্ডারটা এই মানে এই যে আমাকে may not join the transfer post. Okay.
Therefore, my lord, my full submissions order dated 18th April 2022 March with the order dated 5th May 2022 and the interim order EFN was marched with the final order, which was disposed of. Way was disposed of.
What is this what is this way 1920?
1920 challenge way has been filed challenging the reason order dated 13 June 2020.
But how can an order of 22 be challenged in 21?
Way number 20.
Page, you people do not know the facts. Don't go through the papers, you make submission orally. Page 99, you see.
But 5th May, the final order was passed by the tribunal 5th May 2022.
5th May
2022.
Where do we find it?
Yes. Page 103.
That is in the second original application, 675.
675 second way.
First way is 1920 of 21.
I am sorry.
Page 99.
99 was.
Page 9, read the order.
Yes.
What is the subject matter of challenge in this? Applicant is aggrieved as he has been transferred from Kolkata. How? His transfer order was in September 2022.
My learned friend is having all these things.
No, this was my instruction is so for this way number 1920-2021 that was pertaining to different transfer order.
Different transfer
order
of the same person.
No, same person.
No, that is different transfer order.
That is not of the Pritam.
হাইকোর্টে পেন্ডিং আছে এটাও
না তাহলে এখানে প্রীতম different transfer order তো হচ্ছে এটা হ্যাঁ different transfer order that has been also been challenged and the way of my instruction is the writ petition is pending before this honorable court.
Very good.
WPC. This is pertaining to different writ petitions. Now,
এটাই ওর ফার্স্ট 675 বললো
2022 এবার ওখানে বললো যদি না রিলিজ হয় হ্যাঁ যদি নট রিলিজ তাহলে নো কোয়ার্সিভ
ওটা আলাদা এগুলো তো সব ডকুমেন্ট এখানে তো নেই আমরা তো এফিডেভিট ফাইল করিনি এখানে we have not also annexed
if not আর if release no coercive
দুটো পার্ট two parts
এখন ডাইরেকশন নেই
এবারে এই
কি করে এই ফ্যাক্টস গুলো তো আসছে না এখন
নিল যে আমি কোনোদিন এবার জানাতে বললো যে 12টা 12:30টার মধ্যে পেয়েছি কিনা তারপর পরের দিন অ্যাপ্লিকেন্ট
respondents to show that the applicant has been served the release order prior to 12:30 by this date. Which date? মানে যেই ডেটে অর্ডারটা হলো 18/4/2005। আচ্ছা এবার বিচারে কি অর্ডার হলো? বিচারের অর্ডার
whatever manner the petitioner did not annex the all orders and all the ways. That is the problems here. Because we are not well conversant with the all facts because no affidavit directions was given to us to file an affidavit so that we
is
can.
Because tribunal is sleeping. You are saying bogus orders. You are saying tribunal is sleeping. You are taking the advantage.
Kindly
This is your
forget
conduct.
and forgive that language also, Manat. I beg a pardon, Manat. Because what we did, Manat, I can't develop.
The place on record, latest report. 20th of April.
Tribunal raised a question whether the release order was served upon him or not.
Yes. That has been served.
Where do we find?
Where do we
On 11th itself, 11th.
11 it says you may pass. Within the same day, you are passing the transfer order, same day release order, same day stock up from state.
Yes. Not only to him, to other two also.
So maybe
They have
but
not come forward before
kindly,
this.
kindly come to page 100. Respondents.
I'm on 100.
Page 100. Kindly see the third paragraph. Respondents to show
Show
that the
that the
applicant has been served the release order
prior to 11:30
12:30 by this date.
Yes.
What does it mean?
By this date.
By this date means 18th of April, on the date on which the order was passed.
Yes.
Now come to the next order, page 101. Matter was fixed on 20th. Learned Counsel present, Learned Counsel respondents are applicant has been released already. Applicant submits he has not received any release order.
No, এটা তো এটা কি করে আসছে?
This is 675 way. এটা ট্রাইব্যুনাল অর্ডার এত সব
Way
করে
675.
করেছো কিনা দেখাও বলে ইন্ট্রি অর্ডার ইফ এনি উইল কন্টিনিউ.
These 5 questions we have given reply in our reply affidavit.
In your recent order of
30th June.
June 22.
Yes.
Maybe because that is the subject matter. No, 30th June order was challenged in 675.
That was my submission also. 13 June order has been challenged in OA 675.
Where is the 13 June order?
ভুল হচ্ছে না?
How can it
আপনি
be
বলুন না because of from their pleadings we are
No, 13 June order will come later on.
এই যে সেটা হচ্ছে
13 June order challenge in the
1207.
in the pageant way application.
1207.
1207.
120. This is third.
Yeah, 13 June has not come as yet.
Third way. First way, that is at page
so that
99. Way number 192021.
No,
First way.
What was the final order passed in 675? 675, your recent order of 13 June was under challenge. So how you have released him, Mr. Nondi?
120 ওটাতে আমরা চ্যালেঞ্জ ওটা চ্যালেঞ্জ করছি
No, 120 is another similar matter.
Lordship.
That is has no current. I am asking you kindly come to page 100.
100. Yes, my lord.
Please show us that respondents to show that the applicant has been served the release order prior to 12:30 on 18th April. Can you show us that letter?
But may I take instruction here and now I'll give reply. But we are able to produce before your lordship the document showing that on prior to 12:30 p.m. on the date we have served the release order.
Then why didn't you show to the tribunal on 20th of April? That is page 101.
Yes, we have sent the release order through email. We have the proof of evidence of the email ID, email communications.
Why he was not in office?
No, because 11th April he was released. He was struck off from the office records. That's why we sent it through email. He was struck off. His name was struck off from the payroll.
Petitioner is here. He has not received any email copy or nothing else. For that. He has not received anything. He's here.
Will be decided in the content, Mr. Das. We wanted to give some sort of benefit to you, but how can we give?
Well, last occasion, my lord was of the opinion. Right now, we can close the contempt, but respondent should allow the petitioner to resume duty.
No, their contention is, Mr. Das. The transfer order was a combined transfer order of transfer and release.
Same day order.
No, there are two orders.
Just a minute.
Two orders.
State transfer, same
Same
day
day release order.
Now, we understand. Now, this they are giving an explanation in contempt that there was an order of stay of the transfer order.
Yes. But release order was not served upon me. They could not produce any piece of paper.
Yes, we have.
Malad, yes. My client is here. They could not serve the release order. That is why, Malad, here my lord has
That
right.
you argue in the original application.
But
How can
kindly-
we help you here, tell
Yes.
us?
My lord has rightly take the point of 101.
No. First, what is the writ petition? You have challenged which
Writ
order?
petition means, my lord, writ petition I have come before your lordship. As a father of the judiciary, I am complaining before your lordships. A contempt proceeding, tribunal is sleeping tight over this matter. Simply tight over this matter. They could not pronounce me the judgment.
We will ask the tribunal.
Now, my lord,
But direct.
just a minute. You are here bypassing all these things.
No.
Now, for a moment, my lord, my lord can close the contempt. I have no problem. But what is the judicial order? I have got from the tribunal, a competent court, and they are in a ego. But will not comply with this order. A person is more than 2 years without salary. The school-going children education is stopped. Old father and mother depend upon their salary, my lord. And they are on the ego problem, my lord. Nothing else. That is why the tribunal has read upon 1207.
Election of the 9th of September for give 5%. Due to the application. They did not insist. Transfer post facing a post করার জন্য ইনসিস্ট করে and is that
All the argument they are saying, my lord, not on the basis of the records. They are saying the way is disposed of. Way is pending.
Better call for the record. We'll come with affidavit. We'll discuss because what we are submitting based on his pleadings. All records are not with us.
All documents we have been.
If your lordship entertains these applications, then my responsible floodgate may open. Everybody, tomorrow morning, I'll come with 10 applications. But my 10 OA applications are pending there.
Open or not,
That is the point.
We
That
have
is the
the
practical problem.
authority to dispose of even the way application also.
Yes. So
Yes,
way
yes.
is
Dispose of the way
kindly direct the tribunal to dispose of the way within a timeline frame.
Tribunal, there is no bench, nothing else.
I'll come tomorrow morning, 10 applications at least.
যে ওএম
My lord will decide.
অফিস মেমো লাইটে ওর রিপ্রেজেন্টেটিভ ডিসপোজ অফ করতে বললো সেটার কোনো আলোচনা নেই
সেটা তো করলো
আমি সব সেলের ম্যাটার গুলো নিয়ে চলে
সেটা
নিয়ে আসুন। এই ডিপার্টমেন্টের যে কত না ডিপার্টমেন্ট তুলে দিচ্ছে এই ডিপার্টমেন্ট দেখছেন না?
সেটাই হচ্ছে
এক মাস বাজার কিছু থাকবে না ওই
সেই ওই যে
পোস্ট ফিল আপ করছে না কিছুই না উড়ে আছে
ট্রাইব্যুনাল কি বললো আলটিমেটলি ট্রাইব্যুনাল
104
104 হ্যাঁ
এখানে কোনো প্রোটেকশন
না এই যে ট্রাইব্যুনাল বললো যে 3/2021
মামলা করছি
রাইট টিওপিটি ওএম 30
এটা করলে
মানে সেখানে হাজব্যান্ড ওয়াইফ বোধহয় একসঙ্গে থাকতে পারে
তো সেটা তো স্টেট না না
তার উত্তর দিচ্ছে দেখুন যে নো পার্সন হ্যাজ এ ভেস্টেড রাইট টু রিমেইন পোস্ট এট এ পার্টিকুলার
না না তুমি সেই অর্ডারটা থেকে এতদিন ডিস্টার্ব করবে না পেজ 105 টাই আসবে এখানেই তো আটকে যাচ্ছে
হ্যাঁ
Speaking order in the event is found entitled to the due and appropriate order be issued, it is maybe are not entered in all points later disposed of. এখানে কোনো প্রোটেকশন দিল যে প্রোটেকশনটা আগের অর্ডারেও দিয়েছে তাহলে এইটা ডিসপোজ অফ করে দিল বাই অ্যান অর্ডার ডেটেড 5th of May 20 সেইটা চ্যালেঞ্জে যখন ট্রান্সফার অর্ডারটা স্টে করে এবার রিজনিংটা দিচ্ছে ট্রান্সফার অর্ডার স্টে করেছে মানে এই নয় যে Your paragraph 12 of compliance.
But
Do you have a copy?
I have a copy. I've read
No.
twice, thrice. But
Your reasoning is that the meaning of the ordered stay is that
till 4 weeks.
no, the meaning of the order of stay is that the authorities will not insist upon him to join the transferred post. But it cannot be meant to say that he should be allowed to join the post from which he has been
Yes.
transferred. This analogy, this interpretation which you are giving, prima facie, it appears to be fallacious. Because it is not that the release order was stayed, it is the transfer order which was stayed. Release order is a consequential order to the order of transfer.
Lordship.
So if the transfer order is stayed, question of sustenance of the release order does not occasion at all, irrespective of the dispute as to whether it was served upon him or not. This transfer order has been stayed. When the transfer order is stayed, you cannot take a point that tribunal order I will not obey. Because according to me, the tribunal, you are interpreting the tribunal's order. So, Mr. Nondi, it will be difficult for your officer to wriggle out of this. Choice is yours. If you say that I will not allow him to join the post, let the applications be heard out and disposed of by the tribunal. The High Court should not take up on it because it will open a floodgate. That is our discretion. We will explain why we are taking up. But this conduct of yours is not proper. You are simply taking advantage. On one hand, you are saying the transfer order stay has means that I am not taking coercive actions or I am not asking him to join at Delhi. So very good. When you are not asking him to join at Delhi, pay his salary. Don't allow him to join the post. Pay the salary.
But we never stop them not to join in the transfer place of posting.
How will we join, Mr. Nondi? If your officer says this is a bogus concept,
But
we
that
will
is
not abide by.
that is
go to
mere
fine.
pleading.
No, your
Maybe-
officers are harsh.
That's
Your
why
officer says
I have comments my argument as a
whatever
harsh pleading.
tribunal has said, High Court
Well,
has
can you
said,
recall?
forget.
I have comments my argument, but today that is a
Then
harsh pleading, but I'm compelled to read out this paragraph.
Exactly. So
I'm
you
compelled to
better-
read out. But I am not relying on, I do not say, I say this is shameful before any court of law
Exactly.
to make this sort of pleadings and submissions.
That is why we asked you that you talk with your officer. If he says that no, I will stick to this point. All right, we will pass our judgment. We will pass our
But
judgment.
only thing, when my responsible submissions.
No, in that case, there will be no judicial institution in this country. Whatever judicial institution says, if you say that interpretation is this, all right, contempt is filed, we will go to sleep, contempt and this is the tribunal has reserved it and has forgotten it.
I think so, but it appears to me. So, for my understanding, my lord, these pleadings which was made in paragraph 10 just to make a defense.
In El Chaljo Kumar, it is clear.
It is very clear.
That it is the court of first instance. When the court of first instance does not deliver justice, then we have to take up the matter.
Yes. But what the the writ court in exercise of its jurisdiction can also direct the first court to
Why
dispense
should
with
we
the.
direct an institution which is entirely not hearing his plea for such a long
But
period?
if your lordship assume
It's a highly
jurisdictions,
contested
despite the
matter.
fact that the tribunal is functioning, it's not the case the tribunal is non-functional. It is functioning.
Then we delivered our judgment.
But then will not kindly give us an opportunity to submit an affidavit disclosing
No
all
affidavit.
the facts.
No affidavit.
Allow him to join.
You allow him to join. Or you pay the
Now,
salary.
Manat, kindly consider come to the point of joining.
Mr. Nondi, don't allow him to join. You pay his salary.
Now, Manat,
Pay his salary
without exercising any work
Yes,
in the workplace.
we will make it subject to the final decision of the tribunal. Pay him.
Then, Manat, kindly consider one thing. We have to come out with several facts why the post is not available here. Manat, this is ordinance factory. Now the factory, this ordinance board has been transferred to government government companies, which is known as, there are 41 companies transferred to government companies. Public sector, now it has become public sector undertaking. So we are in the transitions mode. Now there are no posts available here. all posts, all the persons, those who are holding the post are getting transferred to different place of India. Here in Delhi, if your lordship kindly consider his representation. So, my lord, it's a really, it was harmful.
Alright, you ask your officer to appear before us.
But the point is this, but there is no scope at all at this moment to permit him to work because there is no post in Calcutta. Now the central government had decided to merge and to frame a government companies. Therefore, the defense public sector undertaking this under the banner of this defense public sector undertaking. Now, ordinance board is now functioning. We are just now in transition mode. Kindly consider this is the factual aspects. So, if your lordship kindly permit him to allow direct him to us to allow him here, so there is no work is needed here. Only post is there in Delhi.
That you ought to have taken in and writ petition before us that this transfer, this order, injunction order is bad. That you could have come.
But my client has been advised to file a reply affidavit disclosing the queries of the tribunal, what is came from the tribunal. So we have given all the reply to the queries of the tribunal. There are 5 queries, 5 points raised by the tribunal in our reply affidavit. Kindly consider I place before lordship.
What happens to the order of stay?
But so far the stay is concerned, if your lordship will not kindly interpret in that way, in my understanding, stay was as such, let a reply be filed by 4 weeks, rejoinder if any to be filed by 2 weeks thereafter, till such time the applicant's transfer shall remain stayed. Transfer means well, order dated 11th April, there are 2 orders on same day. Transfer order and subsequently before afternoon release order. So if transfer order stay, the release means release from the place of posting. The present existing post of
release orders transfer
without the transfer. Yeah, absolutely correct. I appreciate. So transfer order has been stayed. Our interpretation is that was till for a limited days. That was till the filing of reply affidavit. That is 4 weeks. The moment 4 weeks expires, the moment we had submitted reply before the tribunal, so it is automatically it becomes vacated.
Bound to join in a passport post.
He is now duty bound being the government employee.
All his pending proceedings infructuous.
No, I am not. Yes, if ultimately court or tribunal holds the transfer order was justified and in the administration of the justice or administrative or exigencies, his service is required there. So here his enter legal proceedings will go. Or if the court holds vice versa.
Ultimately, OA number 675 was disposed of, directing you to consider his representation dated 3rd December 2021 in the light of the office memo of 2009.
Lordship.
In your order dated 13 June 2022, nowhere you have referred this memo. At least you have referred this memo. At that time, you didn't raise this point. That entire institution is going to transfer to Delhi.
We have enough opportunity now to make comprehensive argument before the tribunal. Assuming this OA application is pending before the tribunal.
Now, when your order dated 13 June 2022 was challenged, then you came up with the plea that entire institution is going on. Factory is going to Delhi. No post is available.
That is the present scenario of the government, the ordinance board.
Where do you have taken that point in the reply?
Yes, first paragraph. I am coming on it. May I kindly come to compliance report first. There, the categorically it has been described.
No, that reply you have filed, Mr. Nondi.
Paragraph 3. Paragraph 3 of my compliance report. The nomenclature which has been changed, we have described. Compliance report, paragraph 3. Accordingly, the government of India had decided to transfer with effect from 1st October 2021 the management, control, operation and maintenance of these 41 units to 7 government companies wholly owned by the government of India, namely so and so, need not go through. Within by
He was an employee of the Ministry of Defense,
No.
Directorate of Ordnance.
Director of Ordnance.
Yes. So, order of transfer issued by the Directorate of Ordnance, not by any one of the companies,
No.
government
Yes.
companies under.
Absolutely correct. Absolutely correct. I appreciate it, Lordship. Order of transfer was issued on 11th April 2022. Now, my lord, today we are not with that notifications because that was not the subject matter here, but now it requires to be considered that by a notification in, as I can recollect, in September 2021, there was a directions, my lord, during this transition period, what would be the status of the employees of Ordnance Board? They would be treated as a deemed employees of the Ordnance Board, and till such time, all the departments should pursue with the matter of.
I want to see the reply to the original application where you have taken this point.
Kindly, I have placed it.
This is the compliance report in
No, no.
contempt.
In both reply, I have also submitted. Has you got it, the reply? Or otherwise, I'll take these 2 copies. Reply.
আমি ঠিক পাস করেছি সেটাই হচ্ছে অর্ডারটা দিচ্ছে এবার যেটা যখন ও চ্যালেঞ্জ করলো হি ডিড নট টেক দি মেইনটেনেবিলিটি পয়েন্ট These 41 units of Ordnance Board,
Lordship.
who are transferring him where? You are
To Delhi?
huh?
Delhi.
Of the Directorate of Ordnance.
Directorate of Ordnance.
Then how does this point comes that 14 units have been, we have decided to corporatize 41 production units. 41 production units, you are not, what is the subject matter of challenge? Is a transfer order issued by the Directorate of Ordnance, not by any managing director of any unit of the Directorate of Ordnance, which decision you took in 2021. So your point of maintainability that it is not because you are arguing on the point that under 14.2 there has to be a notification pertaining to the units. Then you can come and challenge it before the tribunal. But this is not the case. Here the transfer order was by the Director of Ordnance.
In another matter, my lord, I shall make submission with your lordship. Still now it is under the Ministry of Defense. So as per the schedule appendix to the act or the statute. So there, my lord, kindly consider the grounds taken. But in response to his representations, kindly come to clause Roman 5 of my reply affidavit.
24 সেপ্টেম্বর 2021 মেমো এটা তো ওই মেমোটা
Why he is avoiding to get the transfer? It is a condition of service. I put these questions to my learned friend's client.
Can be transferred to the directorate under DDP. What is DDP? DDP?
DDP,
Department of Defense Force.
Department of Defense Production.
Where is your reply to the original application? Have you filed it?
But I have submitted before also.
That is compliance report.
No, reply.
Oh, reply.
Reply affidavit. I have submitted.
Has he used any rejoinder?
But rejoinder.
Have you used any rejoinder?
Rejoinder. We have not received as yet.
Service.
Let him join. The
Let him
the
join
ground
back.
what he kindly consider the ground what he has taken not to transfer me is that to allow me to live with my wife, so to lead conjugal life, rather a healthy conjugal life, and I'm having a little child. But fact is also wrong. His wife is working in Purulia Deven Mahato Medical College.
Yes, husband.
300 kilometers from Calcutta. They never stay together every day. It's not possible. And the petitioner is staying in Kolkata. So that would not be any ground not to transfer me because we will be disturbed in our healthy conjugal life. And so far, now at present my instruction is at present this gentleman is staying in Kollani. Wife is now posted at Kollani. And petitioner is staying in Kolkata. So it should not be the case that if the moment he'll go to Delhi and join his new place of posting, their conjugal life would be disturbed. But there's a condition of service. Whatever may be the reasons, both are government employee. Maybe there are some guidelines. In case of government employees, if wife is or spouses are working in different sector, but transfer order would be made accordingly, matching with them to maintain the healthy conjugal life. Most welcome. That is the policy of the government now. But here, that was not the fact. The reasons or the grounds he shot for not to transfer me.
There is a DOPTOM in this.
I am not denying. It is the central government's policy, DOPTOM.
What do you say, Mr.?
Well, there is a.
Have you filed a rejoinder to the reply, Mr.
I could have filed before the tribunal, my lord.
We will direct the tribunal.
My lord, kindly consider this aspect, my lord. Kindly pass this order.
No.
Kindly, because of this fact, totally, my lord, that officer is a totally vindictive one. He has got the ego in respect of that. Why he has some interim order is there passed by this tribunal. Otherwise, no government department will follow the interim order passed by this tribunal. They can allow me and let the tribunal decide, no problem is there. So why they have not allowed me to resume in duty, my
Very
lord?
well, let him
2 years.
Let him
Well,
join in his place of posting.
How
And in the meantime, we'll release his salary and we'll contest the matter.
And your officer will make a slang language in your
That is
affidavit.
for that reasons we apologize for these things, my lord, or enter thing. What can be done?
Without any challenge against the interim order, we are modifying it.
subject one, it is not, as per my instruction.
It is very unfortunate thing my landed pin is submitting.
And let the parties
There are so
contest the
many
matter here.
who are
And let him
contesting
join.
the more than 2 years in a judicial forum. And not only that, my lord, they have allowed 43 JWM in their office.
Mr. Das, we are not on that. We are on the issue, original application, good, bad, indifferent, it is pending. You are wanting us to take up that jurisdiction from the tribunal.
No, my lord, I am submitting, my lord. My lord has
Show us any authority on
authority,
that.
my lord, that L. Chandra Kumar judgment is
L.
there.
Chandra Kumar says that it is the court of first instance.
Yes, first
There
instance.
is no
But
bar.
I approach you both the first instance.
Right.
Tribunal has granted an interim order.
Yes.
But there are so many things also there. The violation of interim order also a offense in a contempt proceedings. Now tribunal,
Contempt proceedings.
yes. Now the tribunal failed to discharge his duties as a past
That
instance.
is under adjudication is in
One of the
contempt.
section 17.
You have not filed an implementation application.
Yes, I am coming. Section 17 of the Administrative Tribunal Act said, Section 17, the tribunal was given the power, like High Court, suo motu contempt posing anything, what High Court can be done. But tribunal failed to discharge the duty. Therefore, my lord, being a father of the judiciary, on the footing of the L. Chandra Kumar judgment approved before your lawsuit, that this thing has happened before the tribunal.
Tribunal has heard it out. The judgment has been reserved.
My lord, that also my landed pen has misleading before your lawsuit.
Contempt.
Contempt reserved for judgment. But where is pending?
Very well.
Where is
Well,
pending?
You owe Mr.
What are the last occasion, my lord was of the opinion.
I was, because we are trying to help out.
Yes,
We
my
are
lord.
trying to
My
find
lord
out
has
a
rightly formed an opinion that immediate I should be allowed to. Why is there ego? What is the ego, my lord?
It is not a question of ego.
My lord, kindly see the statement. My lord, even if, my lord, the tribunal passed this order,
Mr.
they will
Das,
never comply with this order.
Mr. Das, Union Cabinet on
My lord, this order will not be applicable. I am submitting, kindly see the transfer order. This is in respect of Ordnance Factory. We are the staff of the Defense Department. But I am submitting. My landed pen, very past time, they are misleading in the reply. But there are 42 ordnance factories are there.
Who will adjudicate it?
But I am submitting.
No, who will adjudicate this?
But these documents will not be applicable.
Take the tribunal to adjudicate.
But I am coming. These particular documents will not be applicable. Only for misleading purpose, they are producing these documents. I am submitting. We are the staff of the Department of Defense Production. Our office is Directorate of Ordnance Coordination and Service. We have transferred from DOO to DOO. We are not a factory employee, madam.
We are not on that, Mr. Das. Today, suppose in High Court, single bench passes an interim order.
Yes.
Then the single bench hears out the matter. Judgment is reserved. In many cases it happens. In contempt, there are two approaches. One is, all right, prima facie contempt, come with a reply. Or, as you have said, that the court can issue a rule immediately so that the person can be produced and questioned as to why the order has not been complied. To that effect, the tribunal's contempt application has been reserved for judgment.
When, madam? January 2023.
I understand, Mr. Das, but in that case, all original applications, we are not in a position to fix a cut-off date that statute does not provide.
But madam, one thing, Lordship, kindly appreciate. We have come before this honorable court, that we are helpless. We have taken all the steps, filed appropriate application.
Yes,
but
that is why we are passing the order.
Problem is that despite the judiciary is functioning in our state,
that is
now
why
we are going. Now this petitioner, my lord, his school-going children has already stopped in the education. The oldest father and mothers are there.
Then we have to go into the facts, Mr.
Lordship, kindly dispose of the entire way and CPC before your lordship, my lord. I leave it to your lordship, my lord. My lord, they will, because tribunal is functioning a single bench, my lord. How can it be, my lord? But right now I can produce the decision of the Honorable Apex Court. Under any circumstance, they have framed an ego that they will not allow me to resuming duty.
Director of Ordinance. You are employee of Directorate of
Ordnance.
Ordinance,
Coordination and service, not factory,
Coordination and Services.
not factory employee.
Okay,
And that documents will applicable in respect of factory employee.
you belong to Group A Gazetted Division,
Group B gazetted,
Group B
gazetted officer.
Gazetted Officer.
Kindly see the order of transfer. And this order has been issued by the Defense Department. It is not the Ordnance Factory, my lord. Minister of Defense. DO to DO. He is giving a misleading submission before your lordship, my lord. And their reply, their compliance report is a misleading one.
No, gazetted, shifted, already shifted. পুরো সেকশনে শিফট হয়ে গেছে।
কে বোঝাবে এই সমস্ত যদি মেইন কেসটাই the writ petitioner approached the Learned Central Administrative Tribunal, Kolkata Bench, Kolkata, challenging inter alia an order of transfer writ petitioner বলেছো না? Stop. In the said challenging such and such, he was the writ petitioner. No, the writ petitioner filed an original application being OA 675/2022 before such and such, challenging inter alia such and such. Stop. The said OA, the said original application, in the said original application, initially an interim order was passed on 18th of April 2022, observing inter alia that quote unquote page 100 এর marked out portionটা করে দেবেন। Stop. Subsequent these interim order was passed on. The said original application was ultimately disposed of the said original application was ultimately disposed of by an order dated 5th of May 2022 with a direction বলে marked out part of page 105 করে দেবেন single italics was this with a direction upon the competent authority to consider the writ petitioner's representation in the light of the DOPT OM dated 30th September 2019.
Representation dated 3/12/2021.
Consider the petitioner's representation dated 3/12/2021 in the light of the DOPT OM such and such stuff. Pursuant to such direction, an order was pursuant to such direction, the
Deputy Director.
The respondent number 3 hearing passed an order on 13 June 2022. The said order was again challenged by the writ petitioner in an original application being OA 350/1207/2022 dated 9th of September 2022.
Was challenged. Even order
Stop. In the said original application, an interim order in the said original application, an order was passed on 9 September 2022 directing the respondents to file a reply within 4 weeks, by 4 weeks, rejoinder if any by 3 weeks. In the said original application, an order was passed on 9th September 2022.
Seeking clarification.
No. কি লিখলেন? An order was passed on 9th September 2022 directing the parties to exchange their affidavits and it was also observed that till such time the writ petitioner's transfer shall remain state. ওটা ঢোকাতে বলছো clarification?
Seeking clarification by filing a reply.
আচ্ছা by an order কি লিখলে ওই লাইনটা বলছো? An order was passed on 9 September 2022 directing the respondents directed to file a reply clarifying the points incorporated in paragraph 9 of the order within 4 weeks. Stop. And the petitioner was given a period of 2 weeks to file a rejoinder. The learned tribunal further directed that till such time, directed, bole quote unquote, till such time shall remain state. Page 37, 137. The said original application is still pending before the learned tribunal has not been disposed of finally. Stop. As the said alleging violation of the said order dated 9th of September 2022, the writ petitioner filed an application for contempt before the learned tribunal, in which a compliance report was filed on behalf of the respondents and the contempt application was finally heard and judgment was reserved on 24th of January 2023. Mr. Das learned but judgment, but such judgment is still awaited. In the backdrop of the above facts, the petitioner, Mr. Das learned advocate appearing for the writ petitioner submits that in spite of that the original application has not yet been finally disposed of or has not yet been finally disposed of by the learned tribunal. Stop the contempt application. The final judgment has also not been delivered in the contempt application, and in the till date, and in the process, the petitioner is not in a position to avail the benefits as conferred upon him, to avail the benefits. Has not been disposed of. না তার আগের লাইনটা কি কন্টেম্পট অ্যাপ্লিকেশন কি বলেছো in the contempt application till date. Stop. On one hand, the respondents have not complied with the interim order dated 9 September 2022 and taking advantage of long pendency of the original application and taking advantage of such situation and long pendency of the original application, the writ petitioner has been heckled and harassed and has not been allowed to join the post from which he has been transferred. Mr. Das further submits that the respondents have acted in a vindictive manner. Stop. The petitioner has not been allowed to join the concerned post in spite of an interim order, and he has also not been disbursed his salaries. And as a consequence thereof, the petitioner is suffering unsurmountable inconvenience. In the said sequence, it is incumbent upon this court to take up the final to decide the original application and to grant appropriate relief to the petitioner. Per contra, Mr. Nondi learned advocate appearing for the respondents argues that in terms of the order dated 9 September 2022, though a reply has already been filed on behalf of the respondents, no rejoinder has yet been served upon them by no copy of any rejoinder has yet been served upon the respondents till date. Stop. He further argues that the interim order was that a perusal of the order dated 9th of September 2022 would reveal it was only till such time. কি লিখলে ওই লাইনটা কি লিখলে no till date. Stop. The petitioner has also not mentioned the matter for early hearing with notice to the respondents before the learned tribunal. And for such pendency of the original application, the respondents cannot be blamed. Stop. He further submits that in the contempt application, a compliance report has also been filed by the respondents explaining the compliance has also a compliance report. A compliance report has already been filed by the respondents and the same was filed by the respondents. The contempt application was finally heard on 24th of January 2023 and was reserved for order. We have heard the learned advocates appearing for the respective parties and considered the materials on record. The writ petitioner has been preferred primarily praying for a direction upon the learned tribunal, either to dispose of the original application within a very short period of time or in an alternative way, this court may call for the original records and dispose of the same along with the contempt application. Stop. The factual sequence, next paragraph. The fact stop. Records reveal that the petitioner was transferred and released. From the post of JWM at Kolkata to New Delhi by 2 orders passed on the same date, that is 11th of April 2022. So, in the first original application being there exists a severe dispute. There exists a serious dispute as to whether the release order was at all served upon the petitioner. Fact remains, release order was served upon the petitioner. A perusal of the order dated 9 September 2022 reveals that an interim order was passed to the effect that the petitioner's transfer shall remain state. In spite of such order, the petitioner has not been allowed to join the post from which he has been transferred, and his salaries on and from the month of April 2022 has been withheld till date. though the petitioner tilde. The contempt application filed to that effect. The contempt application filed to that effect, though hard finally had not the contempt application filed to that effect had been reserved for judgment way back on 24th January 2023. Stop. The grievance of the petitioner that he has been made a victim of the circumstances and had suffered due to the rigmarole. Stop. The original application has also not been disposed of. The original application has not been disposed of, and the contempt application has also not been finally disposed of. In such situation, and we appreciate such inconvenience as faced by the petitioner. We appreciate such inconvenience as faced by the petitioner. Stop. The petitioner has availed the remedies as provided under the concerned statute, and is entitled to know the fate of the same. In view thereof, we direct the learned tribunal. You have filed the rejoinder, Mr.
Fine, man. Maybe.
In view thereof,
yes, I
direct the writ petitioner to file the rejoinder to the original application.
If not filed.
Rejoinder, if not filed till date, within a period of 2 weeks, and to serve a copy of serve copies upon the same to all the respondents. Upon such completion of service, the petitioner if not so if not filed within a period of 2 weeks, and the learned tribunal shall finally decide the original application as expeditiously as possible, preferably within a period of 4 weeks thereafter. Stop. We would also request the learned tribunal. We further direct the learned tribunal to finally deliver the judgment in the contempt application, in which such judgment has been reserved since 24th of January 2023. Stop. With the above observations and directions, the writ application.
The interim stay, what is pending, Madam? The interim order which is pending, it may be continuing because nothing has.
Till such time they will consider tribunal. We have recorded that it is still, but we did not record
Problem is this, my lord,
that will.
The present position of my client is so serious, my lord. Regarding financially, he is totally.
You file it within 2 weeks, tribunal will do it within 4 weeks thereafter.
Because, my lord, their attitude, my lordship, is very clear in respect of that. If they are saying that tribunal order is a bogus order.
Mr. Das further submits that Mr. Das further submits that the respondents are very vindictive against the petitioner.
Which I deny, my lord.
Very vindictive against the petitioner. And even though an interim order has been passed by the competent forum, they are not complying with the same, and are taking advantage of long non-disposal of the contempt application.
Which I deny and dispute. So far, my learned friend's statement is concerned. And also kindly record my statement. Yes, sir. Contentions are maybe dispute and controversy.
Let 50% salary may be disbursed.
100% is there.
By this time,
we further direct in the peculiar facts and circumstances of the case. We further direct that no coercive step shall be taken against the petitioner till the final disposal of the original application. ঠিক আছে তো? Within a period of 4 weeks, as expeditiously as possible, within a period of 4 weeks. Stop. With the above observations and directions, the original application is disposed of. They shall have it.
Is appearing on behalf of the respondent. He has went out of station because of certain personal reasons, my lord. As such, my lord, I most humbly pray for not this week.
On the last occasion, they are also not absent there. On the last occasion, it was second time it is
Which
appearing.
matter you are saying?
Item number 11.
It is a case, my lord, for interest on gratuity. Interest on gratuity.
You have got the gratuity.
I have got the gratuity after 12 years. A criminal case was pending not in connection with my service related, and my gratuity was withheld by an order. After 12 years, it was paid when the criminal proceeding was disposed of, and I am been made acquitted honorably, but no interest has been paid. There is I am covered by this honorable Supreme Court judgment, my lords. Rules also provide that.
Come tomorrow?
Yes, yes, my lords.
I am humbly praying for not this week.
Why you are repeatedly taking time? This was
No,
heard
this is the
before
first time.
vacation.
This is the
Not
first
the
time.
first time. We heard it before the vacation. Who is your senior?
Learned Counsel, Mr. Ajit Kumar Mishra.
Okay, Mr. All right, we keep it on Monday. We are not granting adjournment.
I am grateful, my lord.
Monday, my lord, I have some difficulties.
Difficult?
Some difficulties, my lord.
All right, come back on next Wednesday then.
Yes,
I am grateful.
Grateful.
I am grateful.
Yes, next.
No, if you just kindly take it up next week, my lord, in this matter, my lord. I have to find out some judgment, my lord. So.
For the respondent, my lord. That matter where he was used to want to withdraw, my lord.
Classification test.
No. These are the departmental
Withdraw,
proceedings
my lord,
initiated. And my lord, I have challenged the proceedings, my lord, which was, my lord, initiated after 30 years. And interim order was refused by the, my lord, trial court. I am challenging that, my lord, order, my lord. That part.
That
My lord.
on challenge for that.
Yes.
না এটা ওই stale proceedings বলেছে।
Yes. Kindly, my lord, take it up next week any day. My lord. Well, I kindly, my lord, next week. I will. There is a merit. I will argue, my lord. I will argue, my lord.
Argue why you are taking time?
Next week, any day, today, first day, my lord. I have not, my lord, prepared.
We have taken it twice earlier.
No, the matter has not.
We usually do not oppose any adjournment.
My lord, next week, any day, my lord.
It cannot be a matter of course.
Any day, my lord. Next week, my lord. Any day, my lord. Kindly, my lord. First day, my lord,
That
this is
that
my
has to be fixed, my lord, otherwise it will go down, my lord, again it will
no,
come
no,
back.
no, my lord, any time, my
Once
lord.
you fix the matter, my lord, I have no problem. my lord.
Thursday রেখে দাও on Thursday 23rd it will happen. But we are not granting adjournment. Yes, next.
That I appeared for the petitioner.
13.
Yes. On the last occasion, Milord, the matter was taken up. I am for the Bharat Sanchar Nigam Limited, Milord, BSNL.
You're for team.
Bharat Sanchar Nigam Limited. Milord, in this case, Milord, tomorrow is the date for contempt. They are proceeding with the contempt application.
This is you are for Chief General Manager, Calcutta Telephones.
Yes. Now, Milord, what happened? The respondent repeated, the
Who is
respondent.
your other side, Mr. Basu?
Milord, tomorrow is the date for proceeding contempt against my client in before the
দেখি
case.
ফাইলটা দাও।
Service, Milord, was affected. On the last occasion, matter appeared. Your lordships were inclined to take up the matter, but the applicant, Milord, for the
Yes, tell us, Mr. Basu.
yes, Milord, on 12th June 1981, Milord, the respondent applicant, Milord, joined in the Department of Telecommunication. Now, Milord, 2008, a major penalty charge sheet.
12th of June
12th of June 1981.
81.
Milord, the applicant respondent here, the respondent herein joined, Milord, the Department of Telecommunication, which is commonly known as DOT. Now, Milord, in the year 2008, a charge sheet was issued against him, Milord, by the under the Bharat Sanchar Nigam Limited Discipline Appeal Rules 2006, which is a charge of corruption, Milord. He has, Milord, given a false certificate, Milord, while endorsing a bill. I will take your lordship, Milord, to the charge sheet. Be that as it may, by 11/11/2009, Milord, the inquiry was completed. 11/11/2009, the inquiry was completed and the inquiry officer submitted his report. 11/11/2009. Ultimately, Milord, the disciplinary authority issued a final order, Milord, on March 26, 2015. March 26, 2015. Milord, the applicant, the respondent here in Milord, and the applicant before the
Terminated.
no, Milord, some reduction of pay, Milord, not termination. Criminal case was, Milord, pending. I will take your lordship. Now, Milord,
Reduction of pay.
yes.
That was in 2015.
26 March 2015, page 74. Now, Milord, what happened?
That was implemented.
No. Now, Milord, the question, Milord, the propriety of such order. He filed an application before the, Milord, Central Administrative Tribunal. The matter,
In 2019 he filed.
no,
What he was
2016. Now, Milord, 2018, the respondent filed an original application, Milord.
No, no.
Second,
Disciplinary authority order was 2015.
26 March 2015, page 74. Now, Milord, 2016, Milord, he was retired. 31st March 2016, he was retired.
31st March
2016, he retired.
Achha. He retired.
Yes, he retired.
Then
Now, Milord, 2018, Milord,
after
there was
retirement he filed the original application.
yeah, he filed the 27 June 2017. He filed the original first original application. 2017, he filed the first original
After
application
retirement.
after retirement.
Achha. After retirement he filed.
He
Then
filed.
what
He
happened?
questioned, Milord, the propriety of the order dated 26 March 2015.
Very good.
Now, Milord, what happened? Now, Milord, the final order of the Central Administrative Tribunal, 27 June 2018. Milord, this was disposed of.
So why you are saying that there was first original application?
Because there are two original applications. Because he was granted liberty to file a departmental appeal, which he filed, which was disposed of. And accordingly, Milord, 2019, he filed a second original application, which was finally disposed of on 19th April 2022, being the impugned order herein. Now, Milord,
The earlier original application still pending.
in action. Both, that is why, Milord.
Both were taken up together.
No. First was 26 March 2018. The OA application filed on 2017 was disposed of on 26 March 2018.
To go and file a statutory
27 June, yes.
27
June 2018.
Achha. That
Yes.
is go and file a statutory appeal.
No, representation consideration. Representation consideration. This was considered and the final order was passed. Final order was passed, my lord, on 23rd August 2018, page 89. 23rd August 2018, the final order was passed. Rejecting, my lord.
Representation.
Now questioning, my lord, this was a second original application was filed being way number 350/2019, which was ultimately disposed of, allowed, and my lord, on by, my lord, the order dated 19th April 2022. 19th April 2022. Now, my lord, here, if your lordship, my lord, kindly takes pain to turn, my lord, the order impugned. Paragraph 4, my lord. Have your lordships got it? Paragraph 4.
Now,
Now, my lord,
he retired in 31st March 2016.
Right.
So, did you pay his admitted retirement dues?
No, my lord, admitted, my lord, what he says, he is entitled only the provisional pension because two rules, my lord, CCS pension rules and, my lord, the VSNL CDA rules, my lord, both are to be read together. The honorable tribunal was
He is entitled to some benefits, no?
Provisional. But what is the order, my lord, that has been
Charge sheet
passed?
has been rejected, squashed.
No gratuity.
Your
He is
charge sheet has been quashed.
Quashed. Now, my lord, charge sheet has been quashed. The tribunal was under wrong conception or misconception, whatever may be said.
We are not on that. He retired on 31st
March 2016.
He made a representation after retirement that you reconsider my case or anything. That was rejected to be considered.
That was considered, rejected.
Rejected.
Then again, second 1919.
31st March 2016, he retired along with the order of punishment of reduction of pay. So on the basis of reduction,
Criminal case is pending. That is why it creates a clear bar, my lord, in terms of CCS rules, my lord, Rule 37A and Rule 69. I would take your lordship. The judgment paragraph, my lord, kindly cease.
You have not disbursed the provisional pension also.
My lord, he is entitled.
Provisional pension, he is eligible.
Not pension, the provision. The order is for pension.
Mhm.
Order is for pension and all retirement benefits. He is also not entitled to, my lord, get the gratuity also, my lord, in view of the CCS rules. I take my lord's kind attention. Kindly take pain, my lord. Now, my lord, the tribunal was of the opinion
They have filed a contempt application.
Yes, tomorrow is the date. Telephonic instruction. I'm not sure, but the officer, my lord, told my junior, my lord, that tomorrow is the date. SMS also is there.
So you are not paying provisional pension also.
So for my instruction, my lord, I have not paid. But the court said, but still, my lord, I have asked, my lord, only, my lord, the number. My lord, BSNL conduct discipline rules and appeal rules, my lord, 2006 is, my lord, not in contradiction, my lord, the authority, the tribunal was of the view, my lord, the charge sheet was issued under, my lord, this rule against, my lord, the previous misconduct. Now they said, my lord, in view of the promulgation of 2006,
No final orders have been passed with the yeah, they can proceed, but no. Like সেটা বলা সেটা বলা
Provisional pension প্রতি মাসে
my lord, provisional pensions are being paid.
Provisional
He has taken instruction just now.
PF টা দিয়ে দাও।
PF and provisional pension. These
Has
are,
been.
yes.
The present, do you know the number of the contempt application
My lord, I
file?
have asked for the number, my lord.
The present writ petition has been preferred, challenging an order dated
19th April.
dated 19th of April 2022, passed by the learned tribunal in the original application being OA number 350/00101/2019. The records reveal that no one appeared on behalf of the no one appeared on behalf of the respondent number 1.
Only one respondent.
No, there is union of
Sorry, my lord, pro forma respondent. He is the original applicant respondent.
We have respondent number 1. It is good. You don't need to appear for He declared, records reveal that no one appeared on behalf of the respondent number 1 when the matter was last taken up for hearing on 16th of October 2023. Stop. To give a further opportunity to the said respondent to appear and contest, the matter was adjourned and fixed for further and made returnable on 16 November 2023. Stop. Today also, next part. Today also, no one appears on behalf of the respondent number 1. This one number 1. Stop. Mr. Basul and advocate appearing for the writ petitioner submits that alleging violation of the order impugned in the present application, a contempt application has already been in the present petition, a contempt application has contempt application has been filed before the learned tribunal by the respondent number 1, and the same is
likely to be taken up tomorrow.
And the same is likely to be taken up tomorrow. Stop. In view thereof, please the matter for further consideration in the daily supplementary list of this court on 11th December. The respondent number 1 stroke the respondent number 1 shall not proceed with the contempt application before the learned tribunal in the meantime. Yes, the petitioner is directed to
CPC 153 of 23. CPC 1 CC. CC number CC. C full stop C. CC.
Please ask your junior to write it down.
CCP.
ওইটা কন্টেম্পটে ঢুকিয়ে দিও না, ও কাগজটা দিয়ে দাও।
নামটা এটা লিখে দিয়েছি। ডিপলি অবলাইজ ম্যাডাম।
11 ডিসেম্বর করেছো তো? In the meantime, the petitioner shall not proceed with the contempt application before the learned tribunal in the meantime.
Well, only one request, subject to correction, since the contempt is between the contemptor and the contempt. So, Milord, even if he does not proceed, Milord, if the tribunal then says that if your lordship kindly direct the tribunal, whether I'm justified, Milord, because it is between the court and the contemptor. If that is the proposition, subject to correction.
No, that testing would be that so they filed the document. How can we stop the tribunal from considering the issue?
Now, then we'll straightway stay the operation of the order.
Without ascertaining whether provisional pension you are paying or not.
Provisional pension.
That is also not the subject matter, na? Then you show us the documents that you are paying him the provisional pension.
Then we'll kindly keep it tomorrow, I will. Otherwise, there are two aspects. Normally, tribunal, because if the law says, that it is between normally, and second part is, if the order is stayed, the tribunal, at least will be prevented. And at the same time, for the alleged violation during this period.
Place the case then before us. Why you are seeking an inquiry?
Yes. Why? Millard, two dates are required to be taken care of, That 2000, this Department of Telecommunication, in this, first, may I place the order first, Then, paragraph 4. The order dated, 19 April 2022. Para 4, the admitted facts. Para 4 of the admitted facts, from the admitted facts.
Para 4 of
Para 4 of the judgment, impugn judgment. The admitted facts as called out from the pleadings of the parties are as under, that the CBI Anti-Corruption Branch, Kolkata, on getting a complaint of corruption against the applicant, conducted an investigation. After registering an FIR, the investigation report was sent to the Department of Telecom, the competent administrative authority. The Department of Telecom further sent the same, along with its comments, to the Central Vigilance Commission as per norms, that the CVC perused the investigation report of the CBI and the comments of the administrative authority. In concurrence with the findings of the CBI and the administrative authority, CVC tenders its advice of launching prosecution as well as regular departmental action for the major penalty against most of the officers, including the applicant. Accordingly, on observing all relevant formalities, procedures, a major penalty charge sheet was issued against the applicant with a memorandum charge dated 31st December 2008 for alleged processing same bills of contractor by looking the expenditure under improper head of account and for falsely certifying on the reverse of bills, etc., in violation of departmental norms. That the applicant filed his written statement dated 9/1/2009. A departmental inquiry was held on denial of the charges by the applicant. The inquiring authority submitted inquiry report dated 11/11/2009 with the observation of the charges as penalty proved. A copy of the said inquiry report was forwarded to the applicant by the disciplinary authority with a memorandum dated 15/9/2010, giving the applicant an opportunity to make his representation. The applicant submitted his detailed representation on 29/9/2010. That the disciplinary authority issued a final order dated 26 March 2015 after observing.
Mr. Basu, you are sure that it is tomorrow? Contempt application
Tomorrow,
is
sure.
tomorrow.
Message from the officer concerned, instructing officer. AGM legal to 17 November 2000. 6 October, they have said, and CPC number 153 of 2020, tomorrow hearing date.
Personal appearance detected?
No.
It has not yet been heard. That will be the first date even. Do you know who appears for the other side? If we want to hear him and pass because you are wanting stay of the order, na? We will
I said
to
yes.
record.
Now, if your lordship permits us to send the copy of your lordship's order, the first order which your lordship has written, your lordship, the first order that the learned advocate, applicant is requested not to proceed with the contempt, then you'll permit me to send this request to the learned advocate and keep this matter on.
We have directed him not to proceed.
Yes.
Why you are anticipative about that?
I am saying, Millard, if the tribunal says that the law is otherwise.
What is the law? It is between court and contempt.
Contempt, and he is the mere relator informer. if the court finds that element of contempt is there, even if your lordship says,
We have to stay the order then. That
yes.
is why
Now,
we are
Milord,
wanting his
no,
presence.
Milord, why it is required to be heard? The principal question is that the telecommunication department, after merger in the 2000, Milord, new rules have come into play. I'm playing shortly, Milord, which is not contrary to records. Now, this BSNL conduct discipline and appeal rules 2006, it speaks about how to proceed with the matter. Now, the contention was raised before the tribunal that since the misconduct, since this entire action was committed before the merger, now the new rule cannot operate. So everything that was done under the rule 2006 cannot be made operative. The tribunal, Milord, heavily relied on accepted the
basis
contention
of a judgment.
on the basis of a judgment. Now, Milord, this fact, the question is Rule 58.4 of the new rules, Milord, it clearly permits. This is the only interpretation. Only, Milord, I have not given your lordship the entire rule, only the relevant, because Rule 58.4, it says, Milord, any misconduct committed, Rule 58 sub-rule 4. Has your lordship got it? Milord, Rule 58 sub-rule 4, any misconduct committed prior to the issue of this rule, which was misconduct under the superseded rule, shall be deemed to be the misconduct under this rule. Now, the allegation is, Milord, the admitted facts. The allegations are this. The charge sheet is this, that there is a falsification of certificate. So, these charges of corruption, criminal proceeding is also pending. It is still going on. Now, the definition of misconduct that did not trouble the Milord Tribunal's judicial conscience. It is only, Milord, the trouble that Milord trouble the trouble according to tribunal.
No, the charge memo was issued under this Rule 36.
Right, right. So that is, Milord, that disturbed the conscience of the tribunal. How could, Milord, a charge sheet could be issued, Milord, under the Rule 2006? Because they said the misconduct. The Rules 58.4 says any misconduct prior to the issuance of rules. 58.4, any misconduct. That means every misconduct. Any means all, subject to correction. In this case, any misconduct. Now, it is not in dispute that the allegation does not constitute a misconduct. Not a case that, Milord, there is no disciplinary angle. The question is, Milord, about the jurisdiction, that whether the authority was empowered to issue a charge sheet, Milord, under the new rule when the misconduct is committed prior to the issuance of the rule. Our submission is that Rule 2006, 58 sub-rule 4, it does not create any impediment. On the contrary, Milord, it allows us, Milord, to proceed against the employee, against, Milord, any misconduct committed prior to the issuance of rule. This point, Milord, needs to be answered, subject to correction.
The charge sheet was of the year 2008. Charge sheet was of the year 2008. That is prior to coming into operation of these rules.
These rules, no. 2006. Rules came into being, Milord, 2006.
Misconduct was?
Prior to this.
What was the misconduct?
Misconduct, Milord, I take your lordship's kind attention. Page 45.
Page 45.
Absorption to the BSNL. BSNL absorption was 2020.
Milord, the BSNL absorbed, Milord, the Department of Telecommunication in the year 2000. Absorption was made 2000. October 2000. BSNL, Department of Telecommunication, was absorbed by the Bharat Sanchar Nigam Limited in the year October 2000. Month of October, year 2000.
So, Department of Telecom merged with the BSNL.
BSNL was formed, Milord, separately, wherein all the employees working under the, Milord, Department of out of department, Milord, they were absorbed. The applicant was one of the employees who was absorbed by the BSNL in the year 2000, rather, Milord, more specifically October 2000.
What was the policy decision that the Department of Telecom?
The Milord, the 31st March. Sorry, Milord.
What was
we are not aware of the policy decision. We only know the two facts. One is absorption. When this employee was absorbed, the date of absorption is October 2000. He joined the service 81, 98, Milord. 2008, the major penalty charge sheet. By this time, Milord, absorption was also made operative, and not only that, Milord, the new rule came into being. New rules mean Rule 2006. Now, the contention, Milord, the only contention is
he was absorbed in BSNL in 2006.
yes, the allegation. No, absorption 2000, rule came into being 2006. Absorption 2000, October 2000. Misconduct, alleged misconduct prior to 2000. Alleged misconduct prior to 2000. Prior to absorption. That is before 2000. Charge sheet issued in the year 8. Charge sheet was issued 2008. 3 dates are very important. Now, what the tribunal has said, tribunal said that the interim period, Milord, that is, Milord, 2000 to 2006, if this misconduct was happened or did occurred in between this period, then, Milord, this rule could have been invoked. The question is, Milord, the rule does not say so. The rule says any misconduct committed prior to the issue of this rule. That means at any time, any form of misconduct. The tribunal, Milord, subject to correction.
The present writ petition has been preferred, challenging an order dated such and such passed by the learned tribunal in the original application being such and such. তারপরে লিখেছিলেন ওটা থাকে, no one appeared on behalf of Stop. Today also, no one appears on behalf of the respondent number 1 and no accommodation has been sought for. Stop. Mr. Basula, an advocate appearing for the writ petitioners, submits that the learned tribunal failed to appreciate that as per Rule 58 of the learned tribunal are in law in quashing the charge sheet dated 31st of December 2008, failing to appreciate that as per Rule 58 of the Bharat Sanchar Nigam Limited bracket conduct, discipline and appeal bracket close rules, 2006, all pending.
No, any misconduct committed prior to the issue of rules. Any misconduct. It starts
misconduct
committed prior to the
any misconduct committed prior to issuance of the said rules, which was misconduct under the superseded rules,
shall be deemed to be misconduct.
Shall be deemed to be misconduct under the 2006 rules. Mr. Basu further informs this court that no one appears today also no one appears on behalf of the and no accommodation has been set for stop. We have been informed that Mr. Basu Mr. Basu further informs this court that the respondent number 1 has already filed a contempt application
being CC number 153 of 2023.
And the same is fixed for
likely to be taken up.
By the learned tribunal tomorrow. Stop. Prima facie, an arguable case has been made out by the petitioners, and as such, there shall be, and as such, the operation of the order impugned in the present writ petition shall remain stayed till 31st of January 2024. Stop. The respondents would be at liberty to file an affidavit in. Have you incorporated? Was it on affidavits? Was the original application on affidavits?
No.
We need written arguments.
Written arguments.
Written arguments.
Written arguments.
Reply, rejoinder,
No,
file.
no reply, no rejoinder.
Written arguments. Written arguments.
Written arguments. Yeah, but yeah, in 31st of January. We can record that, Mr. Basu, that he is availing provisional pension.
Yes, Milord, on instruction, on telephonic instruction, Milord, AGM legal, kindly.
Acha, answering our query, Mr. Basu, upon telephonic instruction from the
AGM legal, right?
Mr. Rajiv Kumar.
Mr. Rajiv Kumar Datta,
AGM legal.
AGM legal.
Answering our query, Mr. Basu, upon telephonic instruction, submits that the respondent number 1 is being disbursed the provisional pension.
Yes.
We can record.
Yes, and he has also been favored with Milord the provident fund dues.
And he has also been disbursed the provident fund dues. Legal. Upon instruction submits that the petitioner petitioner number 1 has already been disbursed the provident fund dues and is also
Provisional
paid and is also being paid the provisional pension. Till date, the respondents would be at liberty. Written argument করে দিয়েছে আর কি opposition দেবে। আচ্ছা, list the matter for further consideration in the daily supplementary list of this court on 18th December. Stop. The petitioners, the petitioners are directed to immediately communicate this order to the respondent number 1 within a week from date and to file an affidavit of service on the returnable date.
Deeply obliged.
Yes, next. চলো দেখে দাও। এটা ঠিক, এইটা রেখে দিও। What?
Item number 15.
হ্যাঁ,
Kindly take my message.
15 we have passed the order.
13.
13.
Oh, you are 13. You are an unlucky person. Been given a lucky. Yes, what?
My lord, it is my writ petition.
Huh.
It is the writ petition of the SIC corporation. So, my lord, since that
15.
today 15, it will be possibly taken up in the 1st of October itself. So, I don't
But
think
what
a
is-
prayer is required, my lord.
What you are wanting?
Before vacation, I already explained my matter, Lordship, because that day.
Please take the mic. We are not being able to hear what you are saying.
Okay. Lordship, before vacation, I already explained my matter before you, Lordship. That day he was not present.
That?
So, that day he was not present.
Huh.
So,
What do you want, madam?
I want kindly take my matter tomorrow, Lordship. I will be obliged.
So tomorrow it will be taken up.
Okay,
It is in the
Lordship.
list. Why you are mentioned?
Okay, okay. Yes, Lordship.